Mr. Williams was scheduled for jury trial today, and I'm assuming the witnesses are here, correct?
Your Honor, I'm apologizing. Mr. Smith has just informed me that the witnesses did appear on Edgar Williams. May I have a moment to go and speak with them
That the
briefly?
witnesses what?
Are here on Edgar Williams. I was under the impression they were not here.
No, you don't have a time, you don't have a moment to speak with them on the record.
Okay. Okay.
If
Your Honor, at this
they are
point,
here?
They are here.
You have the phone, please. Okay, how are we proceeding?
Well, Your Honor, my intent clearly was to dismiss the case, but the witnesses have appeared. I would obviously wish to speak with them before going forward.
You're gonna have ample time to speak with them because they're not going to trial today.
Yes,
So-
that is correct.
We're upset, Your Honor.
You're not all set.
I'm not leaving. Can I ask you, are you done with me right now while he speaks to witnesses?
No, I'm gonna give you the trial date. September 22nd. September 22nd, work for you, Mr. Morley?
I'll make it work, Your Honor.
Okay, we will reset the trial, September 22nd, 8 AM. And then you'll have an opportunity to speak to your witnesses once we clear the final three trials.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Enjoy your morning.
Thank you. State of Michigan versus Veronica Bullard, 26-01208. Appearance, please.
Ross Martinez for the people.
Michael Puckett with the Public Defender. There's provision of justice, Robert Plus, permission to practice in NCR. On behalf of Ms. Fuller, who's standing to my right.
Okay, your motion is granted. And today was the date for final pre-trial. This is for domestic violence. Necessary witnesses here.
Yes, Your Honor.
Was there an offer extended?
Yes, the people made an offer in which she kind of plead guilty to disturbing the peace on the condition that she agreed to undergo a mental health assessment and follow the recommendations.
Your client wants
Your
to
Honor.
proceed at this time.
If the court would be amenable, my client would like to request another free trial for a short period of time. We were just able to relay this offer to her, so she just needs a little bit of time to think about it, if you'd be willing.
The jury trial is not until the 18th, so she has plenty of time to consider that and let us know 1 week prior to trial if she intends to accept that. Okay, can't wait till the morning of after we didn't subpoena witnesses and held your spot, okay? So you'll let us know if she wants to take the offer 1 week prior to trial.
Yes.
And then we'll see you August 18th at 8 AM. Any additional matters for the record?
Nothing from the people.
Nothing from this room.
You're all set. And then Cole and Davis are downstairs. Cole is on Zoom. State of Michigan versus Robin Cole, 25-02550. Appearance, please.
Ross Martinez for the people.
Morning, Your Honor. Dan Doyle appearing on behalf of Mr. Cole.
Okay, Mr. Cole was scheduled today for final pre-trial. This is for breaking and entering illegal entry. Was your office made aware that he was in custody? Because he had to be remanded, so I don't know if your office was aware that he was in custody and for final pre-trial to send subpoenas.
I mean, I was not aware if he was in custody or not, but I will say that we have not been able to have any contact with any witnesses in this matter. We're not able to see it involved. The combination of lack of contact with any witnesses and it was entry into a vacant house. It's not the kind of thing that we bring up big guns for.
Very good. Okay, Mr. Doyle, how are we proceeding?
And we have no objection to a dismissal, Your Honor.
Well, someone's got a motion. Did you make a motion? to dismiss?
I believed I brought you a no answer.
Oh, okay, sounds good. Okay, let's see. Robin Cole, okay. I do have a nollie. The case will be dismissed without prejudice. Any additional matters for the record?
Nothing from the people.
No, Your Honor. Thank you.
Yeah, you're all set. Thank you.
Am I good to go?
You are free to go, yes. You can bring Davis up.
Gotcha.
State of Michigan versus Anna McMillan Oakley, 26-01267. Appearance, please.
Ross Marshall for the people.
Michael Puckett on behalf of this one.
Okay, Mr. McMillan Oakley is present today. This is for final pre-trial for assault and battery. Are your witnesses here?
Yes, Your Honor, witness did appear and we extended an offer in which Ms. Oakley would plead guilty as charged with an agreement to no upfront jail and consent to youthful offender status.
And Your Honor, I have had an opportunity to speak with Ms. McMillan Oakley about that. At this time, she would respectfully decline that offer and would like this to be set for jury trial.
And scheduled for jury trial August 18th at 8 a.m. in person at the court. Any additional matters for the record?
Nothing from the people.
Nothing from the defense.
You're all set. What's happening? State of Michigan versus Jay Sean Williams, 24-02588, 25-02128. Counsel appearance.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Justin Strott on behalf of JC on the stand to my right.
Okay, this matter was scheduled today for a final pre-trial and a contempt of court. How are we proceeding?
I believe it's, thank you, Your Honor. To my understanding, for speaking to the defense counsels, we probably want to adjourn this matter. The defendant has an open felony case. We're attempting to seek a global resolution whereby the defendant's going to enter a plea to mental health court. With that understanding, yes, this matter be adjourned.
So what has that got to do with my contempts?
Or, well, the contempt, we could go forward with contempt.
Well, the reason that it matters, Your Honor, is because moving forward with the contempt would potentially capture things on the record that can then be used against Ms. Williams later on in the felony disposition.
What has that got to do with the contempt? Because if you did nothing to butcher before the court on the contempt, then that wouldn't be an issue. It's not my problem that you have a pending case if you're violating the court order that now has stemmed and brought about felony assaultive actions. I'm not adjourning two contempts on two separate files. You're going to address them today. So are we having a hearing or are we pleading? What are we doing? Okay, your witness here?
Your Honor, I believe they are. Just give me 1 second. I'll
No
go and
problem.
grab the.
You can have a seat.
Do you want Ms. Williams to sit here, Your Honor, or
No, because I don't know. I don't know how long it's going to take for prosecution to speak, and then we're bringing someone up from custody, I believe. And Mr. Johnson represents one of the victims, I think, but also that person's here on contempt. Yeah. Let's see here. Let's see. Yeah. State of Michigan versus Jay Wiskowski. 26-01140. Parents, please.
Ross Marshall for the people.
Mr. Hardy, who represents Ms. Wiskowski? I'm sorry? I'm pretty sure. It says Hardy. Is it me? She knew. Lord Jesus. You didn't know you represented her?
My apologies on that one, Your Honor.
That's, her apology is not to me. Your apology is to her, because she was very much aware that you represented her. This matter was scheduled for 8 o'clock. It is now 9:07. I am calling the case, and the fact that you don't know that you represent her makes me believe you haven't spoken to her today.
The final pretrial that I had in my calendar was for July 21st, Your Honor. That is my, that's just a mistake, which was bad scheduling.
No, I'm telling you, your apology is to her.
Yes,
It's not to me.
yes, that's my problem.
You don't represent me.
That's my problem. That's what's
This is here.
your.
Your Honor, our victim is not here. That said, we're going to ask that if you left for trial. We have independent witnesses at the location where this occurred who the clerk only subpoenaed the victim, not the independent witnesses. That said, I'm confident that we can get them to appear for trial. Further, we have a video of the assault.
The clerk
Sorry,
subpoenaed
the
who?
clerk's at our office,
Subpoenaed the
the
victim.
victim, but not the other witnesses.
Okay, but the victim is here?
Victim is not here, but I'm saying we can proceed without her.
What witnesses are here?
You don't have any witnesses here. is what I'm saying.
How are we
can
proceeding?
proceed. Well, what I was trying to explain is that we have independent witnesses who were not subpoenaed, who I am confident we can produce at court, even if, and I would be in touch with them beforehand. And even if we didn't, we have a video of the assault. The assault is on video, and I believe we'd be able to authenticate that video through officer witnesses.
It's happening at Rise Recovery?
I believe that is correct.
Okay. Counsel,
We would, with the lack of witnesses, we would look for dismissal. We understand the the position of prosecution. However, I find it tough to think that any of this would get past with due lack of witness. We would like just, if the court is uninclined to dismiss on this oral motion, we would like to schedule for a motion hearing date, so this could be briefed, because we would hold the position that this should be dismissed.
I don't understand how the confrontation clause would be instigated by someone saying, I witnessed an assault, and also here to the assault. I'm not planning to admit any statement.
yeah, it's one thing to say that you witnessed an assault, but how does that give her a right to face the person who accused her of an assault?
Your Honor, the right to confrontation does not equal a right to have the victim who reported the crime testify. If we're going to admit statements from her, then that would be a different situation. We're not planning to admit any statements from the victim of this crime.
Agreed, but how are we getting around her right to face her accuser? Because we don't know if that victim is here, these third-party witnesses do not know. They can only say they saw a certain vantage point. They don't know the underlying issue. They don't know if she was hit first. They don't know.
Well, that's a jury issue. That's a reasonable doubt issue. We have a video of the assault. We do not have a legal obligation.
You've been provided a video of the assault?
It was conveyed with discovery. The right to confront.
I'm asking
Yes,
him a question he has to answer.
Yes, ma'am.
Okay. Continue.
The right to confront witnesses means that they have the right to cross-examine witnesses that we present. The accuser is the state of Michigan. And they have the right to confront and cross-examine witnesses that we present. And we can prove a crime without presenting testimony from the person we're submitting as the victim of the crime.
Today was that was scheduled for a final pretrial. You don't have a single witness here. You want me to hold the case open for you to now get some witnesses that were supposed to be here today.
I am representing as an officer of the court that we are able to proceed in this case. And I will dismiss the case in advance if I
Look,
come to
but
believe
the
that-
purpose of today was for your witnesses to be here. So who are your lay witnesses?
We have an employee at Rise Recovery who was not subpoenaed. Our clerk was under the impression that we were only supposed to subpoena the crime victims. And I've explained that I like for any eyewitnesses to be subpoenaed. But regardless, I am saying that, like, I think I've established that I exercise good faith in representations. I don't play games. If I don't think we can proceed, I will dismiss the case.
Case will continue. The matter will be set for jury trial August 11th at 8 a.m. We have a good working relationship with Rise Recovery. I have no reason to believe that they would not appear in court if subpoenaed. The issue is that they were not subpoenaed. So with that being said, it is reasonable to think that they were not supposed to be subpoenaed, that they would just be subpoenaing the crime victim. I don't think we typically have, you know, how many people we have in the courtroom, if we subpoenaed all the victims every time, or all the witnesses, that I should say. I don't think that's typical. That might be your process, but I don't think it typically happens. So that's probably why the clerk didn't think to subpoena. The other thing is there is video that I'm assuming you've been provided. And so to the extent that the prosecution believes that they can lay proper foundation to use the testimony of the eyewitnesses and or the video, we can proceed. So we'll see you in person on August 11th. Mr. Hardy now knows and remembers that he represents you. So when he sees your face, he knows that you're here for him, okay? Or he'll suspect that.
And Your Honor, we would also like to set for a motion hearing date for that very same time.
I'll set it for a motion hearing prior to that. I'm sorry?
Like a week or two.
Yeah, a week. It could be via Zoom. You don't have to appear in person for that.
We can do August 4th.
Oh, if we're gonna be here anyways, August 4th, you can appear via Zoom. That is.
Okay.
August 4th at 10. Promotion hearing. On, I'm assuming the issue of the confrontation clause, is that what you're motioning?
Correct, Your Honor.
Any additional matters for today's record?
Nothing specific.
No, Your Honor.
Okay, you're all set. We'll get you a notice, man, okay? State of Michigan versus Jalen Shamar Davis, 26-0030, parents, please.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith, appearing on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Mr. Jalen Davis, who is standing to my right.
Okay, this matter is scheduled for jury trial today as well as a hearing.
Yes, I'm motion hearing,
I
yes.
don't know what the motion is.
She just wanted to render her decision
Oh,
from the April 28th motion hearing.
Okay, so this matter is not going to trial today, obviously, because there was a priority trial that took place. So your matter for trial will need to be reset. Okay? What is he investigating?
a separate domestic violence case that he pled guilty on.
Oh, okay.
He's waiting a PSI and we're gonna be sentencing him on August 11th, I believe.
Yeah, so he's in custody for something else.
To be found violations or there's just-
I think we resolved it.
Yeah, I don't know why there's a bunch of police reports in here. I'm trying to understand.
Well, I think that case.
I'm sorry?
Violation in this case.
But they didn't issue the 53.
Okay, as to my, I'm assuming these are old. Except from 25. Oh, you may have, did you attach these with your motion? Maybe that's what these are.
Yes.
Got it,
Yes.
okay, 'cause I'm like, this is from 2021. Okay, as to the motion, of people's motion, which was, their notice of intent to introduce other acts of domestic violence under MCL 768.27B and out of court, hearsay statements under MCL 27C, and 4B, their motion is granted.
Thank you, Your Honor.
Any additional matters for
Nothing
the?
on the people, Your Honor.
Not from defense, Your Honor. We have any date?
July 21st at 8 a.m. July 21st at 8 a.m. Okay, is that a priority? Okay, that is the priority for that one, okay?
21st.
Any additional matters for the record?
Nothing on the people, Your Honor.
Not from defense, Your Honor.
You're all set, thank you. State of Michigan versus Alexis Yurden, 25-03476. Here. She must have been advised prior to that she was gonna, this was gonna be. dismissed. Okay. Did she have an attorney?
D'Angelo.
Yes, Your Honor.
Oh, Mr. Okay.
Ross
Cover your appearance, please.
Ross Martin on behalf of the people.
Dan Doyle on behalf of Ms. Yarden.
Okay, Ms. Yarden is scheduled today for final pretrial. I do have a nollie for this case. People are moving to dismiss without prejudice due to lack of necessary witness, correct?
Yes, Your Honor. Mr. Doyle represented me that his client intended to flee, but I can't in good conscience take that plea knowing that we would not be able to proceed unless the witness appeared on Zoom without me knowing. I have not been able to get a hold of her. Of course, we have the right to reissue as everyone is aware.
So in case you didn't hear that, Ms. Yarden, they do have the right to reissue this case against you, okay?
Okay.
Mr. Doyle?
Oh, wait, hold
Yeah,
on.
I was just gonna say,
It sounds like the witness is here. I have not, I called her. and-
Victim, I'll say victim.
Okay, I apologize. It sounds like the witness is here,
Oh,
so
victim is in the courtroom. So there was an offer?
yes, we made an offer in which she would plead guilty to count 2 with dismissal of count 1.
And Mr. Gloria, how is your client proceeding?
my client will be pleading guilty. There was also a killer boot for no upfront jail.
Yes, that is correct, including agreement no upfront jail.
Just, and this is a recent change to my courtroom policy. Please, I have to be in person now. I am gonna allow her to proceed via Zoom, but she'll appear in person for sentencing. Well, actually, I can just sentence her today because she does have the. You have a victim. I just need to give her criminal history when David returns. Okay, so Ms. Yurden is gonna plead to count 2 of, is that dissemination of sexually explicit material?
Yes, Your Honor.
Okay, is that correct, Ms. Yurden?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
I do.
Thank you. Okay. And you're sitting in a car, you're not driving, correct?
Right.
Okay, and is anyone else in the vehicle with you?
Not at the moment.
And so you understand that the offers for you to plead guilty to count 2, that the people will dismiss count 1, and that there is a killabrew, which is a sentencing agreement of no upfront jail. You understand that?
I do, Your Honor.
Yes.
Okay, and so in order for you to accept that offer, you would have to understand all of your rights, and then you would have to be willing to give all of those rights away. So you have the right in this matter to the presumption that you're innocent. You can maintain your innocence and take this matter to trial and require that the prosecution prove each element of the charges beyond a reasonable doubt. You understand that?
I do.
You have the right to see, hear, or question any witness called to testify against you, the right to have witnesses subpoenaed on your behalf, to give testimony on your behalf, and the right to remain silent, and silence cannot be used against you at your trial. Do you understand that?
I do, Your Honor.
Are you willing to give up each of these rights today?
Yes.
Anyone threatening you to do that?
No.
Has there been any promises extended to get you to give up these rights and plead guilty to count 2?
No, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
You understand that by pleading guilty, it could result in a conviction that you may need to report to your current employer, or you may need to put this on a future job application.
Yes, Your Honor.
This also could result in a conviction that may prohibit you from travel or immigration status that you may be seeking. So you may want to go out the country somewhere, and that country may deny you entry into their country due to a criminal conviction. Do you understand that?
Yes, Your Honor.
As to count 2 of intentional dissemination of sexually explicit material, how do you plead?
Guilty.
Is that because you believe you are guilty?
Yes, Your Honor.
Mr. Doyle, you can water your client.
Yes, Your Honor, thank you. Ms. Sheridan, on or about July 10, 2025, at the location of 2123 Forest Road, Lansing, Michigan. Do you recall that date?
I do.
And what did you do to make you guilty of this offense?
It actually wasn't on that day. I believe it was like June 28th, June 27th,
Okay.
that
And-
time.
Yes.
And I shared a picture that she had sent my fiance and creepers, and then her naked picture, and then her face on my story on social media.
Okay, and she didn't give you authority to submit or post her nude photos on social media?
Correct.
And you agree that she's above 18 years old?
Yes.
Yeah, and I believe that's sufficient for a factual basis.
Any questions from the prosecution?
I apologize if this was asked. Did this happen in the city of Lansing?
Yes.
The people are satisfied with the factual basis.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. Any objection to immediate sentencing?
No objection to immediate sentencing, Your Honor.
Does your victim want to make a statement?
Your Honor, the victim does not wish to make a statement.
You can make allocution.
Yes, Your Honor. I would just indicate for the record that Ms. Sheridan is taking accountability for her actions. She's a single mother of 5 children. She's been in therapy since this incident. She's getting over a toxic relationship, toxic and abusive relationship But nonetheless, she's taking accountability for her actions in this case. I'll just ask that you take all that into consideration.
I mean, Your Honor, if I may be heard, I would just say, obviously it's not lost in the court. This is a very serious crime, even though it's not reflected as such in severity given to it by the legislature. It's the kind of thing that's humiliating to a person and just never fully goes away. So I would request that the court consider that.
Does your client want to make a statement?
Ms. Jordan, did you want to make a statement?
I do, Your Honor.
You can do so at this time.
I would just like to say that I did commit this crime, and I do understand that it is a serious offense. I am not the same person, nor am I in the same space that I was when I did this offense. I was in a very, very toxic and a very, very, very abusive relationship that I am currently pressing felony charges against my ex-fiance for. And that is why the victim has waited several months to even press charges, is because it is in retaliation to this case and is punishment for me trying to get free and have safety from him. I do believe that everything being done is a direct correlation to what he is telling her to do and what she is being directed to do by him, to punish me for standing up for myself. But
Let me interject, because I'm very lost, because based on your factual basis, this was your fiance, and you said that there were pictures that this woman sent your fiance, and now as you're making your statements, it doesn't. I didn't think when you said that it sounded accountable, but it definitely doesn't sound accountable now. Who is the victim to this person that you allege to be your ex-fiance?
I am the victim.
No, you're not the victim. You are the defendant.
I mean, no, not in this case. But
No,
I'm saying
talking about in this case.
Okay.
What relationship does this? Is Miss Riggle?
Yeah, she's his ex-wife.
Okay. So she is his ex-wife. They were not married at the time of this alleged incident, is what you're saying?
Correct.
Okay. And they have children in common?
They don't.
They do not? Okay.
No. Him and I have a child in common.
You and him have children in common. Okay. And so your belief is somehow that this case is stemming from her attempts to retaliate against you?
Correct.
Retaliate for what?
Because I am pressing felony domestic violence charges against my ex-fiance for two violent, ferocious beatings that he did that we are currently also going to court for.
So what does that have to do with Miss Riggle?
Now they are back dating. And
how do you know?
Oh, she comes to all of the court hearings and stuff when I am subpoenaed to go to for my other cases, and he tried to bond out to her house. So
how do you know he tried to? Oh, you were at court and you heard him try to bond out to her house?
Yes.
Okay. And so because of that, you formulated in your belief that the reason why she's pressing charges for you putting her nude photos on public social media is all because you are now an alleged victim in another case. Not because you put her private body on social media.
I would just like to point out that the pictures were posted in June.
I don't want you to point anything out to me. I want you to answer my
Okay.
question. Because I'm trying to get you to understand what you're saying makes no sense.
Okay.
Would you like it if someone put your vagina on Facebook?
She did, Your Honor.
No, no. Did you like it?
I didn't care, honestly.
You don't, oh, you don't care? Okay, well, the average woman cares. The average woman has enough self-respect that they don't want their private body parts publicly exposed for any reason.
Right,
So
and I understand that.
I'm happy to hear that you are in some counseling, because if you don't care that someone would post your private parts on social media, then you really got to do some deep soul searching. So I don't think you're at a place where you can take accountability, because I don't even believe you're being honest about whether or not you care that someone posted your body on social media.
I mean, I took the plea deal. I'm telling you that I did it. I'm telling you the correct dates that it happened. I'm taking full accountability. I'm also
Correct.
just giving you the
You're
full
justifying,
scope of
but you're
the
also
picture.
justifying. When you
I'm not
justify your
justifying.
behavior, this is retaliation. You're saying that's retaliation. You have now gotten into the mind of Miss Riggle, and you have now telling me what she's thinking.
Due to the late charges being filed, I do believe that
and you know what the victim is thinking.
I don't. I'm just giving you my perspective, Your Honor.
Yeah, so my perspective is, regardless if whether or not it is true that she is pressing charges because she's now upset that you are pressing charges against whoever this wonderful gentleman is that you all are arguing over, I disagree. I think that this behavior is egregious. And I think that you should be more focused on the fact that you found yourself in a situation where you were creating this energy, and you're going back and forth, and you're now taking a criminal charge, and it all stemmed from you being in a relationship with someone that you clearly should not have been in a relationship with.
And I realize that, and that's why I've been going to therapy. I'm completely trying to put all of this behind me. I don't care about any of them. I just want to be done with the entire situation, which is why I'm taking the plea. I stated I'm not that person, and I'm not in that spot anymore.
Okay. Are you employed?
I am.
Full-time or part-time?
Full-time.
Okay. I'm going to order her to do 8 months probation. While on probation, you're not to have contact directly or indirectly with Ms. Consuela Riggle, okay?
No problem.
You're not to engage in any assaultive or threatening behavior. You're not to be at any bars or nightclubs. You are required to maintain employment and provide evidence of that to probation. I am going to order for you to participate in anger management group and provide evidence that you are seeking counseling. I am not going to order her to undergo any testing, Mr. Doyle, at this time, because I don't see where this had anything to do with alcohol or substance. It has to do with. Okay, you're not to possess any firearm, ammunition, or weapons of any kind. Do you have any questions about your probation at this time?
How soon do I report to the probation office?
So you're going to come in within the next 48 hours to go see them in person, because you're not here today. Normally, I would send you directly down there to check them. So you'll also be able to report monthly via Zoom, okay?
Okay.
Lastly, there's fines and costs, a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that also must be assessed. Probation is assessed $30 per month for oversight fee. So if you do 8 months, that's $240. So your total fines and costs will be $365. You will make monthly payments on that, okay?
Okay, if I want to pay it all tomorrow, can I do that at the probation office too?
You can absolutely pay it all tomorrow if you would like. And then I was going to also advise you that you do have the right to request early discharge from probation once you've completed half the original term ordered by the court. So 4 months in, if you have complied with my order and participated in anger management and that there's been no violations of your probation within 90 days preceding that request, you can make a request using the court's MC 512 form. That's on the court website, or you can get it from your probation officer. If you file that request, you have to file it with probation, and then you must serve a copy of your request on the prosecutor's office. The prosecutor has 14 days to respond in writing to with any objection to your request for early discharge, okay?
Okay, ma'am, thank you.
No problem. If I set it for a hearing to address your request, you have the right to hire an attorney to represent you, but you do not have the right to court-appointed counsel for any hearing for early discharge. I have never held a hearing for early discharge. I have typically reviewed them off the record, okay?
Okay.
Do you have any questions at this time?
No, Your Honor, thank you.
Okay. Any additional matters for the record today?
Nothing for the people.
No, Your Honor, thank you.
Thank you. You are all set. Don't forget to check in with our probation within 48 hours, okay?
I will not, ma'am, thank you.
Thank you.
The people shared on the JCI rules.
Okay, back on the record in the matter against Jason Williams, appearance again.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Assistant Public Defender Justice Rob on behalf of Jason Williams, who is standing to my right.
How are we proceeding at this time?
With the contested hearing. Your
Your Honor, the people call MV sits to the stand.
You have a seat. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, you can have a seat. I am going to say your voice is very light. I need you to speak up so that the record can pick up your sound, okay? Okay, everything stated in the courtroom must be recorded. That microphone is not going to amplify your voice, and we are running a few fans in here, so it might drown your sound up. So if you feel like you're yelling, it's okay. You just need to elevate your voice so we can hear it. If any of the attorneys object, you need to stop speaking immediately. That requires me to make a ruling on their objection, and then I'll tell you if you're allowed to answer their question or not, okay? Also, all of your responses must be verbal. Head nods and head shakes cannot be heard on the record, so we have to hear your answer, okay? Okay, state your first and last name as well.
Invystit Burton, INVYSTICT -BURTON. You can proceed, counsel.
Thank you, Your Honor. Ms. Burton, I'm gonna direct your attention to May 25th, 2026. Here, do you remember that date?
Yeah,
Do you recognize someone and the president of the courtroom who you encountered on that date?
yeah.
Can you identify that individual by an article of clothing and where they're currently seated in the courtroom?
Yeah, the left side of the courtroom, gray AutoZone shirt. Long braids.
What's that individual's name, if you know it?
JCL Williams.
Your Honor, may the record reflect that the witness has identified the defendant?
Yeah, objection.
No objection, Your Honor.
I know this.
At around 7:02 on May 25th, did you encounter the defendant? Or did you see the defendant, JCI?
Yeah,
Where was this at?
Evergreen Apartment.
Is that in the city of Lansing,
Yes,
County of Ingham, State of Michigan?
yes,
During that time, did you have a open case out against JCI for assault?
yes, I did.
Do you know if he was out on bond on that case?
Yes, he was.
And did he attempt to drive his vehicle into you? Did he attempt to hit you with his vehicle?
From what I thought, yes,
And did he hit a vehicle?
yes, two.
He hit two vehicles? To your understanding, why did this incident happen?
Because of altercation with me and my sister with another girl.
So someone that was not you, there was an altercation between you and the sister and another girl, and he drove into your car and another car.
Yes,
And when he drove or attempted to hit you, you weren't attacking anyone or fighting with anyone when he attempted to hit you, right?
at that point, no.
Okay. No further questions.
Ms. Stroud.
Actually have one more question, Your Honor, if I may.
You can.
Was there some like pepper spray involved or something?
I think so, yeah.
Did the defendant have pepper spray?
Yes.
Okay.
Yeah.
And he threatened you with the pepper spray?
Not me personally.
Was someone?
Who did he threaten? Because all your questions are leading and she's not even paying attention. She ain't objected once. Every single question was leading.
Who did he threaten with the pepper spray?
He just carries it around and be on Facebook like he threatens the whole Lansing with it.
Okay, thank you. No further questions.
Okay. Cross-examination.
Mr. Burton. Who were you with that day?
Them,
Objection,
just-
relevance.
I'm just in my head. I'm not even there. I'm in. You asked all the leading questions. She started off with a who. Y'all want to switch sides?
She said
Who, what, when, where is you? You're the leading.
relevance.
You're supposed to know who she's with. And ask her, is that true?
I do know. Were you with Avani Stitt that day?
She was in her own car.
Okay.
The objections are ruled.
And on that day, were you driving around that apartment complex with some friends or other people?
No, I live in that apartment complex. I was going back to my house.
Okay, so who were you with? Were you with
Jatila
Demisha?
No, I was in a car, just me and my cousin Jatila Knox. They were in their own separate vehicle.
Okay, did you take any videos that day?
Not personally, no.
No, okay, did you appear in any videos that day?
Yes, I
Okay.
would.
Have you seen those videos?
Yep.
If you were to see the video, would you be able to tell me that that's the video you saw yourself in?
Yeah.
And that you,
I would object to relevance.
What's relevant?
well, the prosecutor actually shared these videos with me, Your Honor, as the basis for establishing whether or not this happened.
It was part of the discovery packet.
Yes, Your Honor, it was.
And it's the video that depicts this incident.
It does, Your Honor.
How is this not relevant?
It's very relevant.
Depending on which video.
Well, you're asking the wrong person. You can't ask her. She's gonna show,
Okay.
she can clarify for you
Well,
what video you're talking about.
You brought up Mace. I would like to broach the topic of Mace.
It's on the floor now, but yeah, so your objection's overruled.
Well, I'd like to see the video because
Okay.
the one I'm thinking about has no relevance to this PA 55.
Hope we all get to see that. Hope we all get to see that. It's right now. Right?
Mr. Smith, you recognize the video. You shared this video with me.
Yeah, but I said, what's the relevance to this PA 53?
This is the alleged incident, sir.
Okay.
Your Honor, may I approach the witness?
Yes. You're saying it's not the alleged incident?
I withdraw my objection.
Thank you. Because if it wasn't, I would have to sustain his objection, but if it's the incident, I don't understand.
This is not the exact incident that he drove his car into her, but okay.
Okay. Ms. Burton, could you take a look at this and see if you recognize what's happening in this video? Recognize that video? Okay, you recognize the scene? Yeah. Your Honor, and this is a fair and accurate representation of what happened that day?
Yes, sir.
Your Honor, defense moves to admit this video as exhibit 1. Any objection?
No objection.
Defense 1 is admitted.
We also request to publish it, Your Honor, to the courtroom.
Are
I
you
don't
gonna-
believe that there's anything in it, Your Honor, that is explicit, but the language is a little questionable.
Okay. Oh, you're not in this, so, yeah.
She said,
She said 1. A. It's A, not 1 though. Defense A. Justin Hood.
oh, yeah, you are.
Are you able to enlarge your screen at all?
Oh, Your Honor.
Oh,
I'm gonna do that.
sounds good.
Go to that open field, go. Go to that open.
What y'all trying to do? What y'all trying to do? Put the mace down! Put the mace down! Put the mace down! We got it too! We got it too! What the y'all talking about? Put the mace down, bitch! Put the mace down, bitch! Put the mace down, bitch! Put the mace down! Bitch! Put the mace down, bitch! What are you talking about? What are you talking about, bitch? Put that shit down! Put that shit down! Put that shit down! Put that shit down! Y'all so scary! Y'all so scary! Come on!
Okay, and who are these 2 people? Mine is not, sorry, not updating the same line. Hold on, okay.
Beat that bitch ass! Beat that bitch ass! Beat that bitch ass!
Yeah, who are those 2 people?
Demaya Washington, Avani Smith.
Okay. Are you in this?
Yep, that's me right there.
That's you.
Yellow shirt,
Okay. So you're getting out of which car?
my car, the white car,
Okay, they're both white cars. Which one was yours? The first one or the second
the
one?
Durango.
Okay, so the one in front. So this video's been taken out of your car.
No, not at all. This video's being taken out of the other car that was there. I didn't take any videos.
Okay. But it looks to me like there are a lot of people who, but Jason's not there. He's not in this video.
If you, can I talk? If you see from the back, that car back there, that's where Jason is. Instead of, there's an exit right there. So instead of hitting that exit and walking away, since he knows he has no contact order with me, he proceeds to get out the car and try to chase me. Once he realized the car was no longer, it was rolling, he runs back to the car, and then that's when he rams us.
Let me stop you. You talking about this white car in the back?
Yes, that's where Jason is.
Okay, is he the driver or?
Yes, at
Okay,
this point, he's driving.
okay. And
There's an
so
exit
was
right
there
there.
so he was parked in that point, is what you're saying?
Yes.
And I'm confused. The car started rolling?
I think he got out because of the altercation. He was gonna come fight with her. But I don't think, I'm guessing the car was put in neutral instead of park because he ran back to the car.
Your Honor, there's video of this, and we'll play that video. Since she played this video,
Rule of
we'll play
completeness,
the other.
we
But
might
video.
there is an exit right
I
there.
didn't think it was
If you
relevant
look-
to this particular proceeding.
Okay, I think this might be to address Mace. Is that what we're talking about?
Well, it's to address Mace, Your Honor. It is also to address the fact that there, Ms. Williams is not initiating contact here. There is a fight ongoing with a person that she knows, okay?
Okay. So, Sid Burton, correct? There was someone in the car with Jason?
Yes,
Okay, is that someone who you all are fighting here?
yes.
Okay. Okay, I'm starting to understand a little bit more, because I was lost before.
Okay,
You can continue.
and so at this point, what are you getting out to do?
So get an altercation.
Okay, so you're gonna get into a physical altercation at this point.
That's
Objection.
what she said.
We're here to determine whether or not
There was,
defendant committed a PA 50-degree violation. We are not here to determine whether or not this witness got into a fight with someone else.
correct.
But we're also here to determine the veracity of this witness's statement.
That's true.
And there's a
She's
bigger
already-
picture here.
She's already stated that she got out, but she said it, and then you asked her the same question she just gave you the answer to.
I think you're
So
on
we got to get
the
another
board.
question.
Okay. So at what time does Jason get involved? Because we don't see Jason
About
here.
5 seconds out this video, Jason runs from that white vehicle halfway up to about us. I don't know if he realized the car was not moving, was still moving, and he runs back to the vehicle.
So I need to play this video longer is what you're saying.
You could, but I don't
Okay,
know if it
let's do
would
that.
catch it all the way.
Get that bitch in! Hey, hold on, they trying to hit! He trying to hit motherfuckers! Barney! Barney! Yo!
So we never see Jason in this video. We never hear Jason in this video.
There is video sent to the prosecutor from somebody else that has a case with Jason, showing Jason was the driver of the car. He
Okay.
was in the car at the time of this incident. It was sent to the prosecutor's office as well. So he was the driver. There's video of him getting in the car and moving it. At the time of this exact live as well, he was on his own live. So, yes, so he was on his own live in the car like
I'll play
this.
that.
And another girl sent it in to the other prosecutor. We didn't even send this video in. She recorded him herself on live because Jason tried to lie to the prosecutor, say he was never there. He never did anything. So the girl said, oh, our screen recorded it all. And she sent Jay in that Chrysler 200 at the same time of this video almost. He was putting it in park and going. And that should be sent to the prosecutor as well.
Any other questions for this?
No, Your Honor.
Thank you. Redirect.
Can you let me into the
I
room?
don't see you in the way.
I wasn't even gonna play the video, but
I think we need to, because I don't really understand what happened. I didn't understand what happened after your direct, to be honest. I was gonna have to follow up, because I didn't have a clear enough picture. And especially because your witness's statement originally was is that what she thought, or what it appeared to her was that he was trying to hit her with the vehicle, but I don't know what that means. Was the car rolling by accident? Was it intentional?
let me join the meeting room and we'll clear this up.
I'm being prompted to.
You're a co-host, that's why.
I didn't think I had the jurisdiction to do that.
No, anybody that's co-host had the jurisdiction.
Share. Do you recognize this individual that's on the
Yes.
screen?
That'll be Jason Williams.
That's the defendant.
Yes.
This looks like it's on what, Instagram Live,
Facebook.
Facebook Live.
Mhm.
I'm gonna just fast forward a little bit.
It was taken from whose Facebook Live?
Jason Williams.
Okay.
And this is on the date when you guys got into this incident, right?
Yes. The apartment's in the
In the, right there in the background, that's the apartment complex that you're at, right?
Yes.
And this is Jason in his vehicle, right?
Yep.
And I'm gonna pause it right here. Right there, that white car that you see in the screen. That's your car, that's him following you, right?
Yep, I think so, yeah.
Objection, Your Honor, this image is very blurry at best.
I think it's because we paused it,
Yeah, just
but I seen the vehicle.
and this is on the date of the incident.
Yes, the same date in the same apartment complex.
And were you driving the other vehicle that we just saw?
I was driving, there's 3 vehicles. I was driving the Durango, the white Durango.
Okay, so the one you just showed, what vehicle was that he just showed you at the intersection?
I think that was my car, yeah.
Okay, and then there's another car. Was the other car ahead of you?
Behind, I think I had to, yeah.
Okay, and then you're saying Jay Sean's following behind both of you all?
Yes.
Okay.
Just play it from the beginning because
Is there sound?
maybe some.
When you click share, did you click share sound? When you share screen?
That's all we have.
Okay.
But we show just the picture you showed there shows JCon in his white car following you just minutes before you yell on the other video, hey, he's trying to hit me.
That wasn't me that affected it.
Or someone on the video say, hey, he's trying.
There also is a video of Jason after hitting the hit and run, him getting out the car and fleeing with his friend and from the white vehicle, and he wasn't
Objection, Your
driving.
Honor, we don't have this in.
You said there's,
It's all submitted to the prosecutor.
you said after there's video of what?
After Jason committed the hit and run, he got out and ran from the white vehicle in the driver's seat. And it's all on video.
Okay.
I submitted all my evidence to the prosecutor.
Objection, you don't have the video. It's not a proper objection. that's an issue that, yeah, but it's not being admitted. She can testify that the video was turned over. Representing that. If you don't have that, that's an issue that you got an evidentiary issue that you have to deal with them, but I can't sustain your objection as it relates to her testimony about giving that. Giving that over.
Okay, bottom line, one mistake. He knew you had a assault case out on you.
Okay.
He knew it was you.
Yes.
He followed you in his car.
Yes.
He had attempted to hit you with his car.
Yes.
And he fled on foot.
Yes, and also almost totaled out my vehicle, cost me $14,000 worth of damage. And there was if we note in this video, there was an exit. Autumn Ridge has two different exits. Where Jay's car was parked, there's an exit right there. He wouldn't even have had to pass my vehicle to get out of Autumn Ridge. He could have took that exit right there and hit straight on Willoughby and went on home. But instead he chose to come and do what he did.
Okay, let me clear some stuff up, because your original statement was that you thought that he was intending to hit your vehicle. What makes you think that?
Because after he got out the car and ran up to us, he got back in. At first, I was standing in the middle of the road. I thought he was gonna hit me. I ran out the middle of the road. That's when he went and hit them. I ran to my car.
So the vehicle, he got back in his vehicle. Was the vehicle rolling, is what you said?
I think so.
Okay, so then instead of getting back in the vehicle and putting the vehicle in park, you're saying he accelerated in your direction?
In him and my sister and his friend's direction. He ended up hitting them both and totaling out my sister's vehicle as well. And then his friend got in the car. He backed up in reverse in full force. My Durango was parked legally. Insurance ruled it was illegal park on the side of the street. And he went in full force, hit my car and drove off and got out and did a hit and ran, and they ran.
Okay, thank you. Any further questions?
And you were new, and he hit you, and you were concerned that he was gonna hit you with the car.
And the only reason why I did not move my vehicle is because I thought he was going to hit me, like crash me, like hit me. Because he's known. I thought he was like dangerous, you know?
No further questions.
Thank you. You may be excused.
People call.
Oh, you called someone else.
We'll call Officer.
I don't know if it's necessary.
I don't, but he's here, so.
Okay.
I just want to make sure we.
You can, to the extent that they appeared and you want to get something from them, you can.
Officer Blysley.
It looks like your client is driving in my courtroom, so he's being removed. Yes. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
You can have a seat. State your first and last name.
Officer Lucas Gleasner.
And please spell both.
Lucas, Lucas, Gleasner, Blieesner.
Proceed.
Thank you, Your Honor. Officer Gleasner, are you currently employed?
Yes.
Where are you employed?
Lansing Police Department.
How long have you been employed there?
About 6 months.
What's your current duty with the Lansing Police Department?
Road patrol, typically take calls for service and traffic stop.
I'm going to direct your attention to May 25th, 2026. Were you currently on patrol at that time?
Yes.
Is there someone that's present in court today that you recognize from your patrol on that date?
Yes.
Can you identify that individual by where they're currently seated in the article of voting?
Gray shirt. Daisy and Williams.
Your Honor, the record reflect that the witness has identified the defendant. What brought you into contact with the defendant on that day?
I referred my report.
Yes.
You don't recall what happened?
It was a call for service, Your Honor.
Okay,
So why are we refreshing your recollection?
so what happened when you, for the call for service? What happened?
Called to the address on Fielding Drive for reports that the accused, later identified as Jazian, violated his EA 53 terms by visiting victim.
In this, on another case?
Yes,
Did you, what happened after you got there?
after I got there, took statements, obtained video recording of Jazian outside the address and pepper spraying the air.
So yeah, pepper spray with them at the time that you encountered him?
Say
Or-
again?
Did he have pepper spray with him at the time that you encountered him, or did you see a video of
I
him?
saw a video. He had already left the scene by the time I arrived.
Okay, and in the video you saw, he was pepper
Objection,
spraying
Your Honor,
there.
leading.
Correct.
I think he's trying to clarify the question, so
Yes.
I'll allow it for that purpose,
Okay,
or the answer.
and so based off of your encounter, what happened?
Just took the report and then officers later found the location of Jazian and we arrested him on probable cause for an incident unrelated to this one, as well as the PA 53 violation.
All right, thank you, no further questions.
Cross-examination.
Could you repeat your name for me?
Lucas Leesner?
Bleasner? Okay.
Yes,
Officer Bleasner, so when you got to the scene, you didn't actually encounter Ms. Williams, did you?
no,
Okay, so they wouldn't have obviously had pepper spray on them either, or you wouldn't have found them to have pepper spray on them either, right?
no,
Okay, and you didn't see a video that conclusively shows my client having struck another vehicle or other people, did you?
no.
No further questions.
No redirect.
I thank you, officer, you may be excused. Any other witnesses?
No other witness.
Any witnesses today?
No, Your Honor.
Argument.
Your Honor, you heard the testimony. You saw the video. She explained that the defendant was out on bond in another case. He came to her residence where she lived. He could have exited the parking lot in another direction. He clearly showed that he intended to hit this complaining witness here today after knowing that it was her because she got into an altercation with someone else. For that reason, we ask that you find the other PA3 violation. Both counts.
Your Honor, it is my understanding that we have to, or the people today have to show beyond a reasonable doubt that a contempt is actually valid. I would just point out that none of these videos actually show my client on the scene with Envy. We don't actually see my client hit anybody with the vehicle. There are no timestamps for the video that we do see my client in that would tend to indicate that that was May 26th or May 25th, excuse me. Based on all of that, Your Honor, I would ask that this court find him not guilty or find her not guilty of violating her bond conditions.
The bond condition was that Jayshawn Williams was not to be within 2,000 feet of wherever Envy Stitt Burton was. Video is conclusive. It's very clear. You know that, I know that, and he knows that. And so does Jayshawn, as well as the GPS tether knows that Jayshawn was within 2,000 feet of where the victim was. I don't know why we played this game today and wasted the court's time, because it shows me in the video where you are following behind the vehicle that she said she was driving. I find her testimony to be very credible. That not only did you just follow, it wasn't that you just happened to be passing through and you saw that the people you're not supposed to be around was there, so you got away from them because, hey, I'm not supposed to be around them. So her testimony is that you got out of the vehicle and approached them, and the person that was in the vehicle with them was who they were fighting. That's the person who was in the car with your client. And on top of that, he retreats to the vehicles because maybe he didn't put it in park. I don't know. It's possible that the vehicle was rolling, possible it's not. And then the allegations is now that not only did he follow and be within 2,000 feet, that this was intentional and that he then used his vehicle to close that distance and make contact with these people. And so the violations are sustained to the intent that you wanted to keep some information from for the purposes of felony. It would have been very easy for him to have pled to being within 2,000 feet and kept it there. But now we've opened up the window and the doors and the floodgates for all this other evidence to come in about the potential felony that you have pending. You can address the court for prior sentencing. You can speak right there.
Okay, so like with me not going another way, for one, I didn't know she was there. And if that was where she lived and I wasn't supposed to be within 2,000 feet, should my tether have not went off when I was somewhere?
Should it have not went off?
Shouldn't it have went off? Like,
if you were within the exclusion zone, yes, it would go off. However, based on what I saw, you and what I've heard, you were in the vehicle with someone who was in an altercation with the individuals in the other vehicle, and that you were intentionally traveling behind these other vehicles.
no, in the
Well,
video,
then
it
why
showed
did I see
that-
a video of your vehicle stopped?
In the video, it has showed that it was a car in front of me and a car behind me. They kind of had me like boxed in.
I'm trying to understand what you were doing at Autumn Ridge.
I was there. That's my friend who I was with. Her cousin was out there, so we was out there at her cousin's house.
Okay, but you were driving in the vehicle. You weren't at a house.
At that time,
You were driving and you were live streaming.
I wasn't my phone, but yes.
Even still, you were live streaming that you were driving. And when you noticed, because I can believe that maybe originally, I could believe that if that was the case, maybe originally you didn't know that Miss MD Stitt Burton was in one of those vehicles. I doubt it, but I could believe it if under certain circumstances. But once you found out, because the video shows Miss MD Stitt Burton clearly outside of a vehicle fighting while your vehicle is parked. Why did you not leave? Because now you can't say you didn't know she was there. You did know.
When I seen them fighting, for one, they're fighting from a distance, and she's jumping in the fight.
It doesn't-
like behind the fight.
Agreed. So you
I didn't-
intentionally kept yourself within 2,000 feet.
No, because I did not know that she was the one that had jumped in the fight. It was from a distance. I couldn't see that.
Oh,
part.
you can't. You have issues with seeing.
Just a little, but
Oh,
I couldn't
okay.
see that part. So when I seen that, for one, it was more than one person fighting my friend. So I just trying to get my friend so we can go somewhere. I
You were
know
just
that
trying to
I'm
get your
not-
friend so you could go.
Yes, I know that I'm not supposed to be like, and no matter who it was, no fighting.
Why was
no
there a video
police-
that shows you with mace?
I didn't see that video.
I didn't ask you if you saw the video.
Okay, well, I didn't have mace because I didn't see the video.
You didn't have mace because you didn't see the video?
I didn't have mace.
Oh, okay. You can address the court before I send this.
Your Honor, again,
Okay, wait, I wasn't done.
No, you are done.
Oh,
Because if you think you're gonna sit here and retract or play a mind game with me,
no, I wasn't trying to play a mind game. I was
you're
just
not
saying that
gonna
I-
waste my time. You'll go to jail. If you can't follow court orders, you can go to jail and lose both of your jobs. You knew good and well what you were doing when you were driving around with the person that ended up in a fight with these people. You knew what was going on. That's why you pulled over and whoever that was in your car got out to go fight. You knew who they were with. You knew you weren't supposed to be around. The first thing you said to me the day of your arraignment on the bond violation was, well, I wasn't within the exclusion zone. Didn't matter. You're not supposed to be within 2,000 feet of wherever she is, nor are you supposed to be engaged in any assaultive or threatening behavior. Nor are you to possess any dangerous weapons. Ms. Sharp.
Your Honor, I would just simply point out that It appears that all of these circumstances are a little bit larger and have more context to them than I think what is coming before the court.
I completely, you don't gotta tell me.
I have noticed that.
This is
you
a
are-
lot of ratchet activity on all persons' parts.
I have noticed that you're picking up on these things. I would just point out that this is a group of people that actually grew up together as children, okay? And they have fallen out for whatever reason, but all of them have undergone significant trauma, okay? The loss of children, the loss of siblings, and firsthand, like, you know, holding their siblings while they die, seeing their infants die, like there is a lot going on here. I would simply ask this court to lean into whatever mental health support could be offered to help fix this situation moving forward. To me, it appears there needs to be a lot of healing. I would ask the court, you know, for whatever resolution would make it conducive to that process.
You're telling me that this happened because Jay Sean lost children?
I am saying, no, Jayceon lost a sibling.
Okay.
And that sibling was
this?
disabled and had a trait.
When was this? Jay Sean's right here.
This is a few years ago.
What year is it? 3 years.
They said 13 years ago.
No, it was 2019.
Okay, so Jay Sean lost a loved one in 2019, and because of that.
I'm not sure that there was ever a full recovery, Your Honor. I see.
So you believe Jay Sean needs some mental health
support? I do, not just Jayceon. I think.
Well, Jay Sean's the only person in the jurisdiction of the court at this point. I can't order a victim to go to mental health counseling. If I could, I'd take everybody in that video and put them before the court, because under no circumstances should young men and women be in anybody's community acting like that. That is ridiculous. It shows that no one has self-control. No one has control over their emotions. Emotional intelligence needs to be acquired. It needs to be practiced. It's ridiculous. Anything else?
No.
Thank you.
Yeah, I would just like to say that I think, you know, it starts with accountability. The defendant has never taken accountability at all for his actions in this matter. You know, if he saw two people fighting, that doesn't give him the right to drive his car into two people or his friend or anybody he observed today. I mean, that's disproportionate, you know, at best. And then you heard a lot of lies. He lied about holding pepper spray. He lied about even being there. I mean, he lied since he got arraigned on this matter. So I think, you know, based on the fact that he has other open assaultive cases, the fact that he drove his car into individuals who may have had a disagreement, which is totally disproportionate. I think that the court should consider some sort of incarceration agreement. Thank you.
I agree that there's a lack of accountability. That's problematic and it's concerning. Because if true, because we're not here to address whether or not in fact Jay Sean drove his vehicle into other people and or their vehicles, totaling a vehicle. That's for the circuit court to determine. We're here to determine whether or not he violated the court order. And that's, to me, unequivocally proven. But the fact that even still, Jay Sean refuses to take responsibility and keeps making excuses lets me believe that Jay Sean thinks that he's smarter than the court, he's smarter than the system, and he can bob and weave when he feels like it. And then rely on the fact that he suffered trauma. Everyone suffers trauma. Under no circumstances do you need to find yourself before the court with how many, do we have 3 assaultive cases pending at one time? 3. And now it's escalating. He's now got a felony, while 2 pending assaultive misdemeanors were going through the process. He picks up a felony. involving 2 vehicles while on GPS tether. Anybody who does that has a reckless disregard for order, reckless disregard for good behavior. And that's problematic. Even as you're sitting there, I don't see any accountability. And so I am going to order you to do 3 weekends in jail. That means you will report to Ingham County Jail on Friday, the next 3 weekends. And you will serve the weekend and then you can be released on Monday. And that's your sentence. I'm gonna remind you, you're not to be within 2,000 feet of wherever the alleged victim is for any reason. You understand? It's not time to pose, it's time to answer.
I'm just moving here.
No, I asked you a question and you what you get, thank you. We're open for more contempt if you want. Yeah, I can roll my neck too.
As you should.
Yeah, I know I should. I've earned the right to. You're gonna learn to conduct yourself like an upstanding member of this community. And you're gonna address whatever traumas you have, but you're not gonna address them by lashing out on people. You're not gonna address them by being violent. How old are you? You need to act like it. You need to get control of yourself. You're not in a preschool. If you don't, you'll end up in prison. I can promise you that. Prison or dead. If you can't control yourself. Because one day you're going to meet someone who's a little crazier than you. Keep lashing out and find out. Any additional matters for the record?
Nothing from the people, Your Honor.
Yes, Your Honor. I'm not sure if the complaining witnesses showed up for the 24 case, Your Honor.
Was that a Bonnie Stick?
No, that is the 25 cases. 24-02-588 SM. And I do believe that we are looking for Carnisha Williams, DeAndrea.
Okay, you said the victim didn't show up on what case?
On we believe it's 24-02-588 SM.
What I have is that's MV Stick Burton, but maybe they put the wrong file on here. Let's see. They did. This stuff only says 25 on here. Why is the Simmons file?
Kind of tough when you have so many open cases.
2-4. The judges are clearly confused. They got 2-4 on this one. 24-02588 says there was a bond set that she was not to be in within feet of Stick Burton. That was on the 10th of May. On this file, who is the victim on this? Because the other bond paperwork says Jasmine Ray, DeAndrea Davis, and
Alicia Gutierrez Jackson.
None of those people are here.
Not to my knowledge. Yeah, I can go check the hallway.
Okay, did they put this in the right file? This one. This should be in this file. I don't know why it's. Are we checking? You said you were gonna check?
Yeah, yes.
In that case, Your Honor, the defense moves to dismiss.
Motion is granted for dismissal on file 24-02588. The people do have the right to reissue that charge against you. Do you understand that? You sure? You asked your question.
Okay, so like, if it's dismissed, how they gonna reapproach it? I'm confused.
Easily, if the victims contact the prosecutor and say, hey, we didn't know we had court, we want to prosecute, and they're still within the statutory time frame because it's a statute of limitations, then that means the time frame in which it has to be prosecuted. So if they contact within that time frame, the prosecution has the right to reissue that charge against you. You then have to be rearranged and it starts the clock all over. Okay, so we'll get your dismissal for that one. As to the other assault and battery with Ms. Stitt-Burton, how are we proceeding?
Sounds.
I'm sorry, Your Honor, what's the question?
How's your client proceeding on the other matter? Are we going to jury trial?
Yes, Your Honor, we're still hopeful for a global offer. I do believe that the people are considering a global offer to mental health court.
Okay, when will you find that out?
I just say we set the matter for trial.
It is up for trial, August 18th at 8
So
a.m.
let's continue, let's keep the trial date for now.
Are you saying you won't do a global offer or? Thank you.
Okay, Jay Sean has to report to Ingham County Jail by 5 p.m. On Friday for the next 3 weeks. Any additional matters for the record?
Nothing from the people, Your
How
Honor.
does that work?
You go to Ingham County Jail by 5 p.m.
Okay, and like, what do I do?
What do you mean, what do you do? Whatever they do in jail is what you do. You report to jail, say, I'm here to report to serve my time.
Cool, that's all I'm doing.
Any additional matters?
Nothing further. Thank you.
Thank you.
Okay, is Bonnie Stitt Birdie here? I mean, Bonnie Stitt here.
I'm sorry.
What happened?
That was her.
What happened? You got. I'm gonna scream. Okay, this is the state of Michigan versus Bonnie Stitt, 25-03584. Appearance, please.
Ross Marchmina for the people.
Good morning, man. Please, before Kareem Johnson, for on behalf of Ms. Stitt, P number 71988.
This is up for a bond violation hearing.
That's correct, Your Honor.
Oh. Jesus.
Your Honor, I believe.
What in the world?
We dismissed the underlying case because they were sister. You wanted to.
Got it.
dispose of the bond mileage.
Got it. Okay, so this young lady is your sister? Yeah.
Oh. Yeah, we would,
Where's Miss, where is Miss Stitt-Burton?
She indicated she needed to use the restroom.
Oh, okay.
I have spoken with her. She
wants to rekindle with her sister.
She wants to rekindle with her sister. She does not want to proceed on the bond violation. You understand it's the court's bond violation. She indicated that of course she would comply with the court's order to testify. But you know, from the people's perspective, this is not the most egregious bond violation.
I agree. I agree. You're all set. Thank you.
Thank you.
All right, appreciate it.
Everybody have a good day.
Thank you.
Not Wednesday.
You said it's Wednesday.
Not Wednesday. This is for Wednesdays.
Not here.
Big girls Wednesdays. We were paying.
Wednesdays, we do evictions. Okay, we did all the final pre-trials, correct? Jesus, okay. So we have some people in jail. Is Justin Hood here? He's the one who has to come in person because he was driving in my courtroom.
Your Honor, if I may speak on behalf of Mr. Hood, I did contact him. He indicated to me that he was not driving, but he is at work right now in Detroit. So I would ask the court permission to allow him back if he is able.
He was driving, we saw him. He smoked. Driving and smoking. Yeah. And so he's got to appear in person. Was there an offer?
Yes, Your Honor, the people offered, I believe we offered 7694A in this matter. And I would note that the complaining witness did come to court today. And has just been a very, she actually called our office after the last hearing. She's watching on YouTube. She's been a very active participant. So I don't believe the final pre-trial is necessary.
Jury trial?
Yes, please.
That's fine.
September 22nd at 8 a.m. September 22nd at 8 a.m. You can advise your client.
Thank you.
Thank you. State of Michigan versus Mario Rich, 26-01229 and 26-01236. Appearance, please.
Ross March, meet up for the people.
Is Mario Rich here? Where's
Please, that's Mr.
Where's the Hardy?
Oh, he was trying to log in to talk to.
You know, logging to talk to time is over.
Right here.
No, we're looking for his attorney. But the time to log in and talk is over. We're gonna write the trial. Because I haven't admitted anybody since this hearing, so if you need to talk to somebody, it should, I'm not following. You only for the whole hearing, so now you wanna go. What? Let's see, you're Mario Rich. Here to the record.
This is public defender Joseph Hardy. I'm happy Mr. Rich.
That matter was scheduled today for a pretrial. There's one for a dog fight and a dog at large. And we were resetting this to allow the prosecution to make contact with the victim. How are we proceeding?
Your Honor, this time, the people have made an offer in which the defendant would plead guilty to one count of trespass and agreement to pay restitution for vet bills associated with the euthanasia of the cat that was given. It's my understanding the defendant wishes to set another date, have time to consider the offer and to get information regarding the amount of restitution that will be given. That is accurate.
Okay, so the final pretrial, please. August 4th at 8 a.m. August 4th at 8 a.m. for final pretrial. You have any questions today, Mr. Rich? Any additional matters for the record?
Nothing from the people, not from the defense. Your
We'll
Honor.
get you your notice, okay, sir? Thank you. Okay, let's see, on the record in the matter of the state of Michigan versus Damon Fisher, 26-01099, appearance, please.
Ross March, meet on behalf of the people.
Michael Puckett on behalf of Mr. Fisher, who is appearing in Zoom. Your Honor, I have not had an opportunity to speak with Mr. Fisher. I was asking for the courtroom.
Mr. Fisher has been sitting on here while I ran an entire contempt of court hearing. So for anybody who did not speak to their client while I was running a hearing, your matter's got to be reset. I have a jury trial.
Okay, we can start for a final trial.
Your Honor, I don't think that a final pretrial is necessary in this case. We have a victim who's been actively involved. This was actually originally dismissed to diversion when it was in front of Judge Buchanan, and then I foolishly did not check with diversion if he was eligible or not, and so then it was reissued. The victim has called our office again and again and again for updates, understandably. So I don't believe a final pretrial is necessary.
Okay, we'll do a jury trial. September 22nd, September 22nd at 8 a.m.
And I just would note that we have extended an offer in which he would plead guilty to amended count 1 MDOT less than 200, and he's young enough that he could petition for youthful offender status without our consent.
Any additional matters for the record?
Nothing from the people. Nothing from the attorney.
Okay, it's all set. Oh, wait, oh no, he's missed too many times. He's all set. You're all set, Mr. Fisher. This is State of Michigan versus Bianca Hurd, 26-00762.
Ross Marchina for the people.
Is Bianca Hurd here?
Okay. She had to go feed her meter. I think she should be right back. Assistant Public Defender Justice Strong on behalf of Ms. Hurd.
Is she in the building now? The State of Michigan versus Jason Soller, 25-00533.
Ross Marchina for the people.
Mr. Sauer is now standing.
Okay, Mr. Soller is scheduled for sentencing today. I do have a pre-sentence report that was prepared on June 23rd. Did you get a copy of that?
Yes, Your Honor.
Yes, Your Honor, and I went over that pre-sentence investigation report with Mr. Sauer.
Any reasons to make corrections, updates, or deletions?
None from the people.
I did not see anything in there that needs to be corrected, Your Honor.
Allocution.
Your Honor, I would ask the court to follow the recommendation, which is for costs and fines in the amount of $200 to House of Dane. Currently, Mr. Saller lives with his father in Williamsburg. He is disabled, so he collects Social Security. He currently is in therapy at CMH in the county that he lives in. I think a lot of what's been going on is he's been recently divorced a couple of years ago, so he's been kind of going through a lot. However, he has been going to AA as well, and he also has stated to me that he's never violated his probation that he's currently on. So I would just ask the court to follow the recommendation.
All right, I'll make a statement.
Yes. I'm just sorry for House of Dane for the mailbox I had, and sorry for my dad for bringing them in here. And I've been a lot clearer now because I've been going through AA, and I got a CMH. I've been going counseling, so that's been helping me out through all this. So that's all I got.
Fine is $300, $75 for time victim rights, $50 state minimum cost, and $200 in restitution to House of Dank. $625. Are you paying that today?
Yes.
We'll get you to the criminal traffic window so you can make payment on that, and then that'll resolve this matter. Best wishes to you on your probation in 29th Circuit, okay? State of Michigan versus Kelsey. I'm sorry, someone's just making some noise. I don't know who it is. Okay, Pete Tanner? Yes. Okay, let's see, this is file number 26-01337, appearance please.
Ross Marshall, for the people.
Assistant Public Defender Justice Strong on behalf of Ms. Chelsea P. Tanner. Kelsey P. Tanner. Please stand to the record.
Okay, Ms. Kelsey has a police officer or attempted police officer assault pre-trial today. We reset this for further negotiations. How are we proceeding?
Your Honor, at this time, I have reviewed the file. I don't believe that people will be able to meet the burden of proof, and so we'll be moving for a cross.
Any objection? Okay, the people are going to move to dismiss. The motion is granted, and we will get you a copy in just a moment, okay? So, do you have any questions for the court?
No.
We need a restitution sheet on, what's the name of that file?
Jason Song.
Okay, on the Solar, we do need a restitution form.
I'll get that. That's $200.
Yeah.
Your Honor, is Ms. P. Tanner all set?
Unless you want, I were you, I'd want a copy of my. Ma'am, what's your name on the iPhone?
Marissa Collins.
Okay, thank you. This is the state of Michigan versus Jordan Rucker, 18-01008, appearance, please.
Ross Marshall, for the people.
Good morning, Your Honor. Stephanie Dark for Jordan Rucker. I'm a University of Michigan law student under the supervision of Emily Brule, who's sitting to my right, requesting permission to appear under Rule 8.120.
Permission is granted. And then I see Mr. Rucker is present via Zoom. State your name for the record, please.
Jordan Rucker.
Okay, today's scheduled for a motion to set aside a conviction. Let's see what we have. See. Okay, apparently they did respond, no objection. Okay, the Office of the Attorney General has filed a no objection. Is the county prosecutor making an opinion at this time?
No, Your Honor.
Thank you. Counsel, you can proceed to tell me why the court should grant this motion.
Thank you, Your Honor. May Mr. Rucker be sworn in?
Absolutely. Mr. Rucker, do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can proceed, ma'am.
Right. Mr. Rucker, on March 13th, 2018, did you plead guilty to aggravated domestic violence?
Yes.
And were you discharged from your most recent sentence more than 5 years ago?
Yes.
Have you been convicted of any offenses in the last 5 years?
No.
Are there any other criminal charges pending against you?
No.
Are there any open warrants pending against you?
No.
It is my understanding that before working with legal services, you filed an application to set aside a third-degree retail fraud conviction in the 46th District Court. Is that correct?
Correct.
It is my understanding that in 2019, you agreed to a 74-11 plea deal. Is that correct?
Correct.
Have you ever previously had a conviction for an assaultive crime set aside?
No.
Have you been convicted of more than 3 felonies in the state of Michigan?
No.
Okay. Your Honor, if I may, I'd just like to say a few words in favor of Mr. Rucker's application for set aside.
Please.
So since Mr. Rucker's convictions, he's been very active within his church community. He's currently leading a men's book study there, and he's also a leader in youth ministry and mentorship. He's gone back to school and made a career for himself in marketing and sales. He's been with his current company, Renewal by Anderson, for almost a year in their marketing department. However, he's found it difficult to advance in this industry with his criminal record. This expungement will help him continue getting promoted in the industry and open him up to higher paying job opportunities. And to close, I'd just like to highlight a letter of support from Danielle Williams, his friend and former coworker. She wrote that Jordan approaches life with positivity, humility, and a strong moral compass. He treats others with respect, keeps his word, and shows up consistently for the people who depend on him. For these reasons, we're asking that Your Honor grant Mr. Rucker's expungement. Thank you.
Thank you. Mr. Rucker, what church do you attend?
The Commons in Okemos.
How long have you been a member there?
Almost a year.
And I do see letters of support from is it Mikey Home, and then there's an Ashante Williams, who also submitted letters in support, and a Danielle Williams. And so I reviewed your prior criminal history. Obviously, this application is filed in compliance with the statute, but I also did not see any assaultive convictions since the time of this. I did see one other conviction, but it looks like that was resolved under 7411. But then since then, you've made some meaningful changes in your life, clearly, because you've not had any further interaction with the criminal justice system. So I first want to congratulate you on making whatever changes you made to put yourself on the right track. I think that the information shared today by your attorney is reflective of just the type of cases we look for when we are setting aside a conviction. I believe that your application and your behavior are consistent with the public welfare. And so I will grant your application to set aside the aggravated domestic violence from 2018. It will be assigned for today. So congratulations to you.
Thank you, Your Honor.
No problem. Any additional matters for today's record, counsel?
Nothing from the people.
No, thank you, Your Honor.
Thank you. Best wishes to you all.
Thank you.
Is that Brandon Dennis? State of Michigan versus Brandon Lee Dennis, 25-018252627 and 26-00715 and 716. Appearances, please.
Ross March, meet up for the people on each file. Assistant Public Defender Joseph Hardy, as a Commissioner Dennis. Was apparently being called down.
Okay, Mr. Dennis has 5 dog vaccination cases. How are we proceeding?
Some of his father provided some of these to our office. This time we just asked for a reset. We believe that we can possibly get a resolution.
You said his father provided something?
Yeah, there's 2 dog licenses and show these to the prosecutions for Nipsey and Hustle. Additionally, discovery was not provided on some of these cases. We put in a request for that, mainly just to.
Okay, so we need more time.
August 4th at 10 a.m.
August 4th at 10 a.m. Any additional matters for the record?
No, nothing from the people.
Okay, you're all set, Mr. Dennis.
Thank you.
So, there you go.
You put that in the, waiting room. State of Michigan versus Javon Terry Smith, 25-02764. Appearance, please.
Your Honor, I believe that Mr. Smith was fine handling this one. If I may pop in the hallway and see if he's still here.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith here on behalf of the people.
Okay, this matter was scheduled for a plea and a contempt of court. Which I believe the allegations was that he was stalking and recording the victim. How we proceed?
I think we're prepared for the plea. I don't think we're prepared for the PA 53 violations. I think that there was 2 violations. There was a CCW, which defendant is currently charged with. I don't see there being any reason why that should be disputed. But the other one was that he did follow the complaining witness in this case. That I had to speak with the complaining witness to have her follow up with the police so she could do a police report. I'm not sure what the status of that is yet. So at this point, if however you want to handle it, Judge, we can either have an adjournment until that comes, or we can do a plea today.
Okay, because my understanding is obviously there's these 2 allegations of bond violations, but that the offer was for him to plead to the CCW.
It's going to take the CCW charge in
Plead to count
30th.
2 in this one with 769.4A.
Yes, and we'll dismiss count 1, which was the stalking.
And your client intends to accept all.
Yes, yes, Your Honor.
That's correct. I can't hear you.
Yes.
Okay, you have an advice of rights.
I thought we turned it in the last.
So you thought what?
I think you turned it in last time.
There's no advice of rights in this file. I don't believe it. Also, you know what is? The way. What'd you think? Just gonna wait a minute. Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. Okay, you can put your hand down. This is an advice of rights and plea information sheet. I'm going to put today's date on it. That's your signature?
Yeah.
You went over these rights with your attorney?
Yeah.
You understand all of these rights? So that means you're gonna waive your right to the presumption that you're innocent until proven guilty, correct? You're also going to waive your right to require that the prosecution prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. A right to remain silent in any trial and not have silence be used against you, and your right to subpoena witnesses that will testify on your behalf. You understand that? You also will waive any rights to present any defenses that you believe you have to this charge. You understand that? Is anyone threatening you to do this? Any promises being extended in exchange for a guilty plea today? Are you on probation at this time? Do you understand that by pleading guilty, it could result in a conviction that you may need to report to your current employer? It also could have impact on where you can travel or give immigration status. As the counsel of domestic violence, how do you plead? Is that because you believe you're guilty? Tell me what you did to make you guilty of domestic violence.
So.
You say who? You shoved Micah Smith? Okay, and who was Micah Smith to you at the time that you did this? A partner or a friend? Okay, there was no romantic relationship? Okay, so there was a romantic relationship at the time? You were dating? Okay, and what date did this happen?
March or May.
May 31st, 2025?
This is May.
Okay, okay, and where did it take place?
Outside of one.
Okay, and when you shoved her, that was not in self-defense, correct? Okay. Any additional questions?
You are satisfied, Your Honor.
Not at this time, Your Honor.
When satisfied with the factual basis, I'll accept your plea. Your plea be voluntarily and intelligently made. Matter scheduled for sentencing August 25th at 9 o'clock in the morning. You need to meet with our probation department so they can schedule a pre-sentence interview. So before you leave, we'll have you check in with them to schedule that. And then that way they'll give a recommendation about how they believe you are to be sentenced, okay? We will reschedule the bond violation to the date and time of August 25th. Any additional matters for today's work?
Nothing, Your Honor. Nothing from the people, just I want to iterate the fact that the no contact order is still in place.
Nothing from this match, Your Honor.
Okay, he recalls, correct? Okay, you're on GPS tether also, correct? Okay, I think we're aware. There won't be any more violations or allegations of violations, because he wouldn't violate stuff. Correct? Any additional matters? You're awesome. We'll get you downstairs to probation.
Thank you, Your Honor.
Thank you. State of Michigan versus Renee Zellick, 12-04405.
Ross March, we have for the people.
Ms. Stark, do you have an attorney at all?
No, I don't.
Okay, no worries. State your name for the record.
Renee Ann Zeller.
Okay, today was the day scheduled for a motion to set aside conviction. Let's see, it does appear that the agent still did not respond. We've given them sufficient time to respond, so we'll move on. And my understanding is that the prosecution is not taking a position at this time.
That is correct, Your Honor.
Okay. And I believe, I'm aware, I recall at our last hearing, you did share some information about the circumstances surrounding this matter. And you since have been working and engaging in other activity.
Going to church and my son goes to CMH. I've been in Waverly Wellness for 2 years. I finished my associate's degree in human and health services for 2.5 years through Ultimate Medical Academy online out of Clearwater, Florida.
and I've been having a hard time getting a job because of my criminal background.
I can imagine that, but your relationship with the children is back on track.
Yeah, my
Everything's good.
daughter sent an email too, if you want to read it.
I do not have the email, but I trust that you and your daughter, because they're adults now.
Yeah.
This is a 2012 case. I trust that you all are back on track and that
Yeah,
you've been doing.
I have been for like 10, 12 years, as old as my son.
Very good. And I don't see any convictions since this date. So I find that your behavior and this application is consistent with the public welfare. I'm going to grant your application and set this aside. Okay?
Oh, thank you so much.
You're welcome. Congratulations to you.
God bless you. Thank you.
Same to you. You're all set.
All right, thank you.
You're welcome.
Do I pick it up or?
Pick
does
what
it-
up?
Does it get mailed to me?
Yeah, with this order here is going to go to the state police so that they can remove or make your record non-public.
Okay, thank you.
You're welcome. Okay, and I don't know who this person is, but Miss Collins has been here for some time, and then there's State of Michigan versus Denasia Bibbs, 26-01211, parents case.
Ross March, Unit for the People.
Michael Pluckett with the Public Defender Office on behalf of Ms. Phillips, who is appearing in music.
Ms. Bibbs is present. This matter was reset because she was eligible for diversion.
Yes, I consulted with our people running our diversion program and learned that she actually is not eligible for diversion, but it does sound like we have reached a plea agreement that is going to get us to the same place diversion would have gotten us.
Okay, thank you. Okay, so we're gonna reduce it to retail fraud third degree with consent to sentencing under HYTA status.
That
Correct?
is correct, Your Honor.
Yes, Your Honor.
That's what you want to do, Ms. Bibbs?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Okay, you can put your hand down. Before you can plead guilty, you first need to understand your rights, and that includes their right to the presumption that you are innocent. So you are innocent until proven guilty. You have the right to maintain your innocence and require the prosecutor prove your guilt by proving each element beyond a reasonable doubt, okay?
Okay.
You have the right to see, hear, or question any witness called to testify against you, the right to have witnesses subpoenaed that will testify on your behalf, and the right to remain silent and not have silence be used against you. Do you understand each of those rights?
I do.
And are you willing to waive all of those rights today for you to plead guilty to the reduced charge of retail fraud third degree?
Yes, ma'am.
Okay, no one is threatening you to get you to waive your rights and plead guilty. Is that correct?
Nobody forced me, no, or
Anyone
coerced me,
promise
no.
you- Anybody promising you anything to get you to plead guilty?
No,
Okay. Are you on probation or on parole?
no,
You understand that by pleading guilty, it could result in a conviction that you may need to report to your current employer, or you may need to put this conviction on a future job application.
yes,
It also could have impact on where you can travel or get immigration status. So you may want to go visit a certain country and they may not allow you access to their country based on a criminal conviction. You understand that?
yes, ma'am.
As to retail fraud third degree, how do you plead?
Guilty,
Is that because you believe you are guilty?
yes.
Factual basis, counsel.
Ms. Bibbs, on or around March 22nd, 2026, about 5:45 p.m., were you at the Walmart at 3225 Center Boulevard, Lansing, Michigan, in the county of Union?
I believe so.
Is that May 6th?
March 22nd.
I have May 6th on my citation.
Oh, let's double check. One. And the ticket, I have March 22nd.
Yes.
You have a different citation than I have? Mr. Martinez, what's the date of incident?
I'm checking.
I'm looking at the citation. The birthday's in March. But it says May 6, 2026 at 3:50 PM is the date of incident.
The police report I have is March 22nd at 2:19 PM.
Well, then this wasn't properly issued. I actually don't understand how we got a retail fraud on a citation in the first place. A ticket was issued for retail fraud. I have no idea how this officer thought he had the authority to issue a retail fraud for that under those circumstances. I don't believe that this was properly issued. Let's go off the record. Well, it will call next case. Without anything, I don't know if we can do that. Let's see. This is the State of Michigan versus Marissa Collins, 26-01-205 and 206.
Cross March meetup for the people.
Assistant Public Defender Joseph Hargan has Ms. Collins.
Okay, Ms. Collins is present via Zoom. These are dog license vaccinations. We reset these so that she can get the dog into compliance. How are we proceeding?
So unfortunately, she has not been able to obtain the licenses just yet, but she did receive the rabies vaccination paperwork, so she has made progress on it. We would just ask for another reset, 3 weeks if possible, just to allow her to get another paycheck. Because right now, the only thing that's holding up the licenses is lack of funds.
August 4th at 10. August 4th at 10.
Thank you, Your Honor.
No problem. Any additional matters for the record?
Nothing for people.
No, Your Honor.
Okay, you're all set for today, ma'am.
Thank you.
You're welcome. State of Michigan versus Kasib Al Fadai, 26-00498. Yes, please.
Cross March meetup for the people.
Assistant Public Defender Joseph Hargan on behalf of Kasib Al Fadai.
Okay, this is a domestic violence. There was no offer at the last court date. How are we proceeding?
At this point, we would just like to request a final pretrial just to see if there is a witness cooperation.
There's still no offer.
The people have offered 769.48 in this matter. I have not been able to get the victim on the phone.
Communicated this offer with my client when it was received yesterday. He's still currently thinking it over, but as it was, we'd still like that final pretrial.
Final pretrial, August 4th at 8 a.m. Jury trial, September 22nd at 8 a.m. August 4th, 8 a.m. in person for your final pretrial, and September 21st, 8 a.m. for jury trial, okay? Do you have any questions today? Any additional matters for the record?
Nothing for people.
No, Your Honor.
You're all set. I don't know if this is in my reading. Let's see, is W.D. Jones here? Elizabeth Hausler?
Yes, present.
How can we help you? Which matter are you here for?
I am here to observe the current expungement case.
Whose expungement case?
I am observing Emily Burrell.
That's not on my document. Oh, was that for you? Oh, okay. Oh, you were supposed to be with Emily Burrell? Is that what you're saying?
That's correct. I'm just observing, Your Honor.
Okay, that matter was already handled.
Okay.
So that's all set.
All right. Thank you so much. Appreciate it.
No problem. Okay, let's see. State of Michigan versus W.D. Jones 26-01227, appearance case.
Ross Marchman for the people.
W.D. Jones, pro se.
File for W.D. Jones. Sorry. This was set for a dog vicious tendencies. How we proceed?
Yes, Your Honor. A couple things. I did have an opportunity to speak with Mr. Jones. We had what I think you would agree was a very productive conversation. I think that we're close to a resolution. We of course filed some motions. One thing that I did clarify with him that is a little confusing. The complaint uses the language has vicious habits and molests passersby, yada, yada. But it cites Article 9, Section 1E of the Ingham County Animal Control Ordinance. And the language of that ordinance, that section of the ordinance simply says that someone is guilty of a misdemeanor if the owner's dog at any time, whether licensed or unlicensed, wearing a collar, not wearing collar, attacks or bites another animal, regardless of former viciousness or knowledge of such viciousness. So I think the source of confusion regarding this charge was, well, this happened on private property. How was it charged this way? But even though the charging language says this, it's charged under a provision that's just straight up dog bite. I can, this was issued on a complaint. I assume the affidavit of probable cause would sustain that there was a dog bite. I can consult with the hires up about whether we need to file an amended complaint or not, but regardless, I've made an offer in which he would plead to simply trespass with an agreement to pay restitution. It sounds like he's interested in that offer, but wants some time to think about it. And I will need a chance to try and follow up with the owner of the dog about what that bill are looking like. So that was me talking a lot to say that we would like another. And I think that we'll be able to resolve.
Okay, I'm looking at these motions. You insert copies of these. There was defendant's motion for bill of particulars. What are you looking for exactly?
I was looking for clarification on the charge itself, what he mentioned on in the private property versus the public roadways, the way it was worded.
Okay, and then there's a defendant's motion in limine to exclude speculative testimony. That sounds like it's a motion for trial, because there won't be any testimony prior to trial. So we won't really have to address that now. Defendant's motion to dismiss for insufficient evidence of identification. Identification of whom?
Which dog, or if one of my dogs do it. There was no witness. The witness stated he did not see it.
Oh, you have more than one dog.
Correct. I have multiple dogs. They have multiple dogs in their own yard.
Okay, so it sounds like there's some complexities here, including how it was charged. You need additional time.
Yeah, I think that I think that we're close to resolving it. All the motions and charging language complexities notwithstanding, I think that we're close to resolution.
Are we set to go continue to negotiate if resolution is possible? July 21st at 10:30. July 21st at 10:30. Okay. Do you have any questions today?
Oh, man. No, Your Honor.
Any additional matters for the record?
I nothing from the people.
Back on the record in the matter of the state of Michigan versus Bianca Bird. This is 26-00726.
Ross Marchino for the people.
Defender Justice Straub on behalf of Ms. Heard, standing to my right.
Ms. Heard is here for sentencing, and we have a pre-sentence report with a recommendation. It was prepared on the 2nd of July. Counsel, did you get a copy?
Yes, Your Honor.
Yes, Your Honor.
People have no deletions, additions, corrections.
Thank you. What about you, Ms. Straub?
The defense also has no deletions, changes, or corrections.
Okay. No updates, corrections, deletions. We can make allocation.
Your Honor, I would just like to point out that Ms. Heard has been forthcoming about the error in her decision making. She has also completed some mitigation work. I sent her a couple of courses that she could take, and she did indeed take those courses, Your Honor. Specifically, she took driver safety awareness training, as well as understanding driving safety and laws. I don't believe that there was any property damage that was caused by her actions, Your Honor. And I would just simply ask the court to consider those facts.
Should your partner make a statement?
One more notable thing, Your Honor. It doesn't appear that she has been diagnosed with any kind of substance use disorder. It doesn't look like she's got either alcohol use disorder or cannabis use disorder. So I just wanted to point that out. It does appear also that she has a medical marijuana card.
So she did undergo an assessment?
Yes, she did.
It says here the SAS-4 screening results indicate not evidence of random responding and a high probability for a substance use disorder.
Your Honor, I was just reading, Ms. Heard did not meet the diagnostic criteria for an alcohol use disorder, and Ms. Heard did not meet the diagnostic criteria for cannabis use disorder. Maybe I misunderstood. This is a little technical, admittedly. I could have misunderstood.
Yeah, so I don't even think that sentence was probably even written in a way that makes it even clear.
Okay.
So to the extent that there was some confusion there, I think we could all be confused by that statement.
Okay.
But what I do have here is a person who has previously been convicted of an impaired, and then now a new conviction for operating while intoxicated, impaired, or under the use of a controlled substance, second offense. And my understanding of the circumstances, at least as Mrs. Hurd would stated, it was that she admitted to having been drinking, but that she was in a situation where altercation took place. And I think as she termed it in her paperwork, it was a situation that had nothing to do with you. Is that correct? What happened?
Fight broke out, a crash actually broke out after hours. We helped the girl out the car. The girl ended up having beef with people, and the people that she had beef with pulled up to the site, and we were helping her, assisting her out of the car. She thought we were the person who wanted to fight the girl that crashed her car. Thought we were her people trying to fight her.
Okay, so
And
you
we
got
swung on. And we went from there.
Okay, so the police were called and you were sitting in the vehicle when the police were called. Okay, and at that point, though, the vehicle was not on, there were no lights or anything on. No, yeah, you were, at least the report says you were not cooperative. That's what the report says.
Not cooperative
with the police, like you became uncooperative, meaning.
Well, I didn't really become uncooperative. They didn't seem like they wanted to help, so I told them to leave.
That sounds uncooperative.
I mean, they weren't helping me.
Well, they're asking you questions, and I don't know what the questions were.
I was trying to show them video of what happened, and they didn't want to see it, basically. So probably because I was intoxicated, and I probably was aggressive, but.
It says she became agitated and uncooperative.
Okay, so agitated as in because they weren't trying to.
Yeah, well, you gotta let them steer the investigation.
Yes.
Do you have a history in investigations?
No.
Okay. You have a police background?
No.
Okay. So we usually let the professionals usually do their job. And if we don't think that they did it properly, there are mechanisms that you can employ later to help supplement their investigation. But it's not helpful to become agitated and just say, forget it. That's not, especially if you think you're a victim of a crime. You just, I don't know, it could have been a young officer. I'm not saying all the officers do the best investigation. We have a lot of newer officers out here. It requires some level of patience, and you were under the influence. And even if they questioned you about whether or not you were driving or other things, that's reasonable, because when they arrive, you are behind the wheel of a car, albeit the car is not on. The issue then becomes they return. And now the vehicle, I believe, was on the west side of the street.
I never moved.
Okay, it might have been on the west side of the street at the same time, but I just noticed that they put the location the second time. Okay, it's on the west side of the street, and now the lights are on. I'm sorry?
They couldn't.
That's what it says. The lights to the vehicle were activated.
Well, I wasn't planning on moving because I called the police back.
It's not about whether or not you were planning on moving. This is where the point I'm trying to get to, because I think there's been people who understand the statute and the law as it relates to operating. Operating while influenced, as soon as you put that key in ignition, you may not be intending to drive. It might be cold and you just wanted to turn the heat on. You've now operated under the influence and violated the law. And so there was no allegations that you drove the vehicle. That wasn't the allegation. The allegation is that you operated the motor vehicle. You understand that? And so it's an unfortunate situation you found yourself in. I think education is paramount here. I'm glad that your attorney had you get some further education. That's why I'm taking the time to explain to you how simple it is to violate that statute. It doesn't mean you drove the vehicle or that you even had intentions of driving the vehicle, because as you stated, you did call the police back to the scene of the vehicle, of the incident, because you believe you were a victim of an assault. But unfortunately, as you said, you found yourself here and this is what you're dealing with. And so it's unfortunate because it was a violation, albeit maybe not your intention to even ever drive the vehicle. But I think you've learned something here, a huge lesson. And unfortunately, sometimes as a young adult, lessons come with costs. And I think you experienced the cost of this lesson. So looking at your driving record, someone could assume that you are just out drinking and driving and doing, and that doesn't sound like it. It sounds like you probably tried to learn from your first situation. But found yourself in this one, because when you're intoxicated, even if you were going to sit on the other side of the vehicle, in the passenger seat, you can't operate the vehicle in any form. Do you understand that? Okay. Do you have the evidence of her completing this program that you sent her to?
Yes, Your Honor, I can forward those to Ms. Nash. I was not able to print them off. I just got them yesterday. I can also bring them to the court next week if that's better.
If you have an email, that's fine too. Was it the MAD Impact Panel?
No, it was not the MAD Impact Panel, Your Honor. There are 2 online driving courses, and understanding driving safety and laws, and then a driver safety awareness training.
Okay, and you spent 4 days in jail for this? Same credit for 4 days.
I maybe did 12 hours. I was downtown and they took me to Mason to get on the alcohol study for 2 weeks.
All right, I'm trying to understand why he said 7 days jail credit for 4. Oh, he wants me to sentence you to 7 days credit for 4, but you didn't even spend 4 days in jail. Is what you're saying.
Didn't see that recommendation, Your Honor.
I'm sorry?
I didn't see the 7 days.
Yeah, 7 days in the Ingham County Jail, credit for 4 days, 3 days suspended upon successful completion of 12 months.
Suspended.
Suspend 3 days upon successful completion. 12 months. I'm sorry, is vehicle immobilization mandatory? Second offense, I think it is. Vehicle immobilization is mandatory unless the vehicle is ordered forfeited. She pled straight up to the charge, correct?
No, Your Honor, I thought she pled to first.
It says it here. She did plead to it first. So this whole pre-sentence report is wrong. Because he put that you pled to the second. And he put, exactly, that's what the whole recommendation comes from, the second. Okay, because that's why I'm like, why are we, okay, got it. Because if you had pled to the second, I gotta immobilize your vehicle for up to 180 days. But that's not where we are. You pled to the first. I just looked at what I wrote. I don't know where you got that information. So we'll disregard his. Yeah, didn't I'm sorry. You got it. I'm telling, didn't I make you feel like we can have a trusting relationship here?
Now, yeah.
Oh, not before this?
No facts.
Sweating.
I mean, I thought we had a rapport. I was gonna give you fines and costs.
We have rapport.
Well, the way it was going.
No, we have rapport. We have rapport.
Great.
Yeah, nonetheless, I think you've learned a huge lesson and you're still gonna suffer the consequence because you have this extra conviction. I don't believe that additional probation is warranted. I do think additional education is warranted. So I am going to order that she does complete the mat and back panel within the next 90 days. But I will send it to the fines and costs other than that.
Thank you.
So let's see here. There is a $75 crime victim rights fee that must be assessed as a $50 state minimum cost. There was no OWI cost recovery to the police, I don't believe. They didn't submit it. Do you have anything different than that, Mr. Machina?
No, Your Honor.
So we will not order OWI cost recovery, but there is prosecutor recovery of $120 that will be assessed. Did I say $75 for 50 minutes? If I didn't, let me say it again, $50 state minimum cost. I'll waive discretionary fines of plus at this time. Total is $245. Are you paying that today?
I could pay some of it today.
How much can you pay today?
I'm not sure. I have my phone. On me.
Let's see what
I could for sure pay that 75.
Defendant to pay 75 today. And balance within 90 days. As well as the victim, the matter victim, okay? Got it. You have any questions at this time?
No.
Okay, so we're going to do what two things in the future?
Drinking and driving.
Or operating, no
Or
drinking, and
operating.
operating. You were not convicted of drinking and driving. You were convicted of drinking and
Operating.
operating.
I'm impaired.
Okay, so you can't operate the motor vehicle. You understand that? Okay, as soon as you put that key in the ignition, it's considered an operation of the motor vehicle, okay? And then we're gonna do what? While the officers are investigating our calls.
Cooperate.
Yep, and be patient. Even if they're not doing the greatest job, because you can go later and speak to their command sergeant and show them the video or turn over or whatever after we get beyond that, okay? Okay. We'll get you to the criminal traffic window. You'll be all set for today. That's what you're saying.
Thank you.
You're welcome. Okay, I need to go check on this real quick for Bibbs. Down to probation too. They gotta redo it. Yeah, they have to, it was the wrong charge. Yeah, they have to redo that. He has to fix that because he did the wrong charge on that. That's Kathy.
This is really bad
That's
timing.
downstairs, yeah.
But we were
Yeah, it wasn't
supposed
Joe.
to address bond for Mr. Fisher. Are we able to do that?
It's not, it's a Okay, Ms. Bibbs?
Yes, ma'am.
Thank you. We're back on the record in the matter of the state of Michigan versus Denasia Bibbs. And I did look into this further. I am going to have this case dismissed. It was issued on a citation, so that means there can't be a motion to amend it, the date. So it was not properly issued, and my understanding is that your former unit chief, Ms. Tusco, had already advised the police that they need to not issue these on citations. So,
Oh, I remember that being, okay.
and so it was
I
issued on a
remember
citation,
discussing that with her.
but then didn't put the correct date.
I
So
think
it
that
can't even
Judge
be amended.
had reached out to her about police issuing tickets.
Yes, so this is dismissed. If the prosecution really wants it that bad, they'll reissue it against you and
You won't.
you will, yeah. And so if they do have the right to reissue, but it sounds like they're not going to reissue this against you.
There was,
Okay.
the property was recovered. We're not
You're all
gonna-
set.
I
If
also
you
do,
case
I
it-
did want to say that I had a issue for the civil part of this as well, and they reached out to me and I paid that as well for, like, I guess court fees or something along that side on the civil side of it. So,
I'm not aware of that, but you're all set on the criminal side.
okay, all right, thank you.
Thank you. And let me. Yeah. On the record in the matter of the state of Michigan versus Maurice Lamar Gary, this is 26-0002 SM with the parents.
Ross Marshmino for the people.
Assistant Public Defender Joseph Hardy, once again, appearing on behalf of Mr. Gary, who's making his way to the podium.
Okay, the jury has arrived and the docket has been cleared. We are ready to call the company preliminary matters.
The people have no preliminary matters.
Nothing from the defense, Your Honor. Actually, we would have one preliminary matter. It's my understanding that the other witness has arrived. Due to them both allegedly witnessing the same event, we would request a witness separation order.
No objection. Oh, I met Haley's baby this weekend. I met Haley's baby this weekend. He's very cute guy.
I guess it takes some looking in the records. Now you have to look around it. All rise for the jury. You gotta push all the way in so everyone can get in. I'm actually gonna put 7 of you in the jury booth now. Juror number 1, Melissa Campbell. You can walk around this way. Juror number 2, Anne Marie Lowe. Number 1 in first, please. Juror number 3, Brandy Denise Blair. Juror number 4, Pamela Ann Ratchewit. Juror number 5, Anthony Charles Reed. Juror number 6, Avane Polito. And juror number 7, Julie Louise Force. So everyone should have spaces spread out. Like this. Okay. Absolutely. You can be seated. Okay, good afternoon, ladies and gentlemen. I am Judge Kristen D. Simmons, and it is my pleasure and privilege to welcome you to the 54A District Court of Ingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and the prosecution has the right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selections, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on a jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this particular case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask all of you to stand and swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as a juror in this case. If you have a religious belief against taking an oath, you may instead affirm that you will answer all the questions truthfully, fully, and honestly. All potential jurors, please stand. You can raise your right hand. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? If you do so, you signify by saying I do. Thank you. You can be seated. I'm going to introduce members of my court staff. To my right is Ms. Addie Nash, that is my judicial assistant and court reporter. And to my left standing here is Mr. David Warnsley, he is the court officer. This is a criminal case. It involves 2 counts of the charge of assault and battery, which I will explain more fully later. This charge has been made against the defendant, whose name is Maurice Gary. The defendant's attorney is Mr. Joseph Hardy. Mr. Hardy, if you can stand, introduce yourself, and then please list any witnesses that you anticipate calling today at trial.
Hi, my name is Joseph Hardy, Assistant Public Defender with the Union County Public Defender's Office. This is my co-counsel, Ms. Jessica Stroud. And today, it is our intent to call one single witness, that being my client, Mr. Maurice Gary.
Okay, the assistant prosecuting attorney is Mr. Ross Marchmina. Mr. Marchmina, please introduce yourself and list any witnesses you anticipate calling today.
Hello, everyone. As the judge indicated, my name is Ross Marchmina. I'm the prosecuting attorney for Union County. I plan to call 3 witnesses: Warren Wright, Garrett Hoyt, and Lansing Police Officer Sean Tuna.
Does anyone in the jury box or anyone waiting to be selected to go in the jury box know the defendant? If you know the defendant, raise your hand. Okay, and does anyone know any of the lawyers or witnesses that were named? If you do, raise your hand. Right.
Well, we have a hand.
Oh, you have a hand, ma'am?
I just know Officer Latino.
I'm sorry?
I know the officer.
You know him through your work or, okay, because you are a dispatcher, correct? Right. Okay. Anybody else know any of the officers?
I'm Mike. I don't know them by name, but we do a lot of work with them.
Okay. Okay, so you know them possibly through your work. Okay, very good. Okay, we think the trial will be completed today. There's a possibility though, because we are getting a late start, because we had a full docket on top of the jury trial, that it could run into tomorrow. Does the length of trial present any hardship for anyone? If so, raise your hand. Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical problem that makes you unable to sit for 2 or 3 hours at a time? Or does anyone have a problem with sight or hearing? So if you have a medical condition where you cannot sit, so I would say for longer than an hour, raise your hand. Okay. If you can hear me, raise your hand. Very good. So everyone can hear me? Okay, and everyone, this is a small courtroom, so everyone can see clearly? Very good. Again, this is a criminal case. The paper used to charge the defendant is called a complaint. The complaint in this case charges the defendant, Maurice Gary, with crimes of 2 counts of assault and battery, and reads as follows. On or about December 31st, 2025, at or near the address in count 1 of 1717 North High Street, Lansing, Michigan, that the defendant did in count 1 allegedly make an assault or assault and battery upon the following person, being a Garrett Allen Fort, contrary to MCL 750.811. And in count 2, on or about December 31st, at the address of 1717 North High Street, that the defendant did allegedly make an assault or assault and battery upon the following person, a Warren Ezekiel Wright, contrary to MCL 750.81. The defendant has pled not guilty to the charge. You must, or you should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal trial so that the defendant and the jury can hear the charges. You must not think that it is evidence that he is guilty or that he must be guilty because he was charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, you must then find the defendant not guilty. A reasonable doubt is an honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. We will now begin with voir dire. Mr. Marshman, you may proceed.
Thank you. Thank you all for being here in this small crowded courtroom on a warm day. Everyone's ideal Tuesday. So I'll do my best not to take too long. It's a pretty straightforward case. The purpose of this part of the proceeding is for me to get to know you guys a little bit and sort of suss out who is a good fit to be on this jury in this case. Right? Does that make sense to everybody here? We'll just try to get to know everyone a little bit. We'll start down here with juror number 1. I think you're an assistant manager at Rover. Is that the one over in Cranbourne? Yes. Okay. Why can I love that? Love moving around there. How long have you been doing that?
18 years.
Okay, 18 years. I assume you like it there. What do you like about it?
It's a nice place to work. The people I work with,
How long until we get home with records? Okay, my wife is very excited. She loves Halloween. Have you ever been on a jury before?
Yes.
What kind of case was it?
One was underage drinking and one was rape.
Okay, there's a big gap in the seriousness. Did you wind up being on the jury? Start with the underage victim. How long ago?
Oh, wow. 10 years ago.
Maybe 10 years ago. What was the outcome at that time? And then the rape case, how long was that?
Maybe a couple years after that.
What was the outcome at that time? And then where were those trials held? Right here in Union County?
Yeah.
And I assume that the rape one was in the other building.
Yeah.
Do you remember which judges in front of? Do you remember anything about the prosecutor or the defense attorney? No? Okay. I'll let my colleagues know what's not.
We can't hear you.
Sorry. Get a microphone closer.
We can't hear you. There's nothing with the microphone.
Okay. Okay. The acoustics. Stand back here a little bit. Now, moving on to juror 2. Says that you are a retired corrections officer. Are you currently working in any other role?
I do some contract prosecuting.
Okay, what kind of security do you do?
For executives, manufacturing things, whatever.
How do you enjoy that?
Yeah.
Great. How long have you been doing the contract work?
2 years.
Okay. Have you ever been on a jury before? How do you feel about possibly being on a jury today? Fine with you. Juror number 3. You are a public safety officer. It looks like you work for the Lansing schools. Do you work at any particular school?
No, I feel it now. I don't.
Is there a school you like to work at better than the other ones? No. Now you mentioned that you work with Lansing police sometimes. You're not sure though if you know Sean Latino?
I mean, no, I don't know in person for sure. I just may have seen him around or something.
Okay, and although he's not going to be testifying, there was a different officer involved in William Turbo, if you know him. And given that there's some proximity with Mr. Latino, are you going to be able to judge his credibility the same way you would judge the credibility of any other witness? And working with the police in some capacities that have you coming into this meeting one way or the other? Okay. Now, juror number 4 says that you are retired. What did you do before retirement?
Shoplifters
You caught shoplifters.
at Meyer,
Okay, okay.
31 years.
We they call that asset protection. Is that what we did? Okay. Is that a Meyer in Union County? So then have you interacted with people from the prosecutor's office?
Years ago,
A long time. How long have you been retired?
4 years.
4 years. Are you the Meyer you worked at is in the city of Lansing?
Yeah, I worked at most of them.
Okay. Have you ever, testified in a retail fraud case? Was that here in this building? I guess that experience, does it have you coming into this leaning one way or the other? Or no? And do you have any familiarity with any of the officer witnesses I've mentioned?
Probably not now.
It's been 4 years now. Have you been working for Lansing Police yet? Have you ever been on a jury? How do you feel about being on a jury today? Now, juror number 5, alignment check. What does that mean?
So it's basically just like mechanics work and do the major stuff, and then I just come and fix it up, make it perfect so that everything works right.
How long have you been doing that?
About 2 years.
How do you like it?
I like it.
What do you like about it?
I'm a pretty hands-on guy. I like to get it done, serve other people.
You like working with your hands, like working with people? Have you ever been on a jury before?
No.
How do you feel about possibly being on one today? Now, juror number 6, 911 dispatcher. What kind of interactions do you have with police as a 911 dispatcher?
We talk to them all throughout the day, tell them where to go. Sometimes we come in. Sometimes we'll do a special event and do a public relations with them.
And how well, I'm sorry for already answered this, how well do you know Sean Martinez?
I don't know him well, I just see him, talk to him on the radio.
And do you think that you would be able to fairly assess his credibility as a witness today? You guys don't hang out socially, not gonna go hang out with him in the bar after court today? Okay, perfect. And have you ever been on a jury before? How do you feel about possibly being on one today? Feel fine. And juror number 7 says you're a project and process manager. What kind of projects and processes do you manage?
I work mostly on IT installation, right? So a software upgrade, software implementations that affect more than just one unit. So they're across the whole organization to coordinate training. Almost always that involves a process change. If you normally used, let's say used Word on your computer and then had to switch to a different software, so we would have training.
How long have you been doing that?
Most of my career, 1 year and a third.
How do you enjoy that?
I do like pretty cats and putting the puzzle together.
Okay. My dad worked in the software world for most of my life, and people would ask me what he does, and I'd be like, I don't know, some of the software. So
I don't know either. I don't install it. I am the one who coordinates it to make sure it goes done
okay.
properly.
I think that he would sell software and train people on how to use the software. I think. I don't particularly know. Have you ever been on a jury before?
I've been summoned. I've never served in the jury.
So you've been in the peanut gallery, but have you ever gotten all the way up here before? Are you hoping to get to the finish line today, or do you not have a strong feeling one way or the other?
I would love to have this resolved today, if that's what you mean.
No, I just mean, I guess, are you hoping to be on the jury? Do you have any thoughts one way or the other on possibly being on the jury?
It's a civic duty.
Now, getting a little more into what happened, I don't have a lot more. We'll start with juror 2 this time. Actually, let's do it this way. Show of hands, are any of you familiar with the Cristo Rey Community Center? Okay, we'll start with juror 3. What is sort of your relationship to Cristo Rey Community Center?
I mean, I don't have.
Oh, you just know that. That was poorly phrased. Have you you just know of it, have been there before?
No.
Okay, perfect. And juror number 6, what about you? Have you been to the Cristo Rey Community Center?
I went there for church when I was younger, and then my friend Kristen that over here.
Okay. Now, this offense is alleged to have occurred at the Cristo Rey Community Center. Are you guys both able to just set aside any personal knowledge you have of this location? Okay. Don't find yourself thinking, well, I know that over here is this, therefore you gotta wipe your mind blank of any knowledge you have. Does that make sense? Okay. And it's not often that this instruction, if this does happen to spill into tomorrow, can everyone here be trusted not to go visit the Cristo Rey Community Center? Can you all be trusted to do that? It's not usually when I hear the instruction of don't visit the crime scene, I'm like, are they going to go to some rando's house and ask to look at the living room? But this time it actually is a little more applicable. Okay, this time we will start with juror 2. Juror 2, how serious does something need to be an assault?
Yes, you have to listen to everyone's statements to determine that.
And now, to clarify, this is a misdemeanor. No one's dead. No one got shot, anything like that. Let me give some examples. Let's say I walk up to Mr. Harvey here and I just clock him right in the face. Is that an assault?
Yeah.
Okay. Now let's say I walk up to him, I just give him a little shove. What about that? Is that an assault? Okay. Now, juror number 3, what about you? How serious is it?
I feel like assault, show, assault.
Yeah, which is like, this is a misdemeanor, and they have felony assault, they have all kinds of different things. But just basically putting your hands on someone is assault.
Yes, for some, it's, I guess, serious when the person really doesn't want to touch.
Now, juror number 4, same question. How serious does something need to be an assault? Hitting. So putting your hands, pushing someone, that is enough to be an assault. Juror number 5, same question.
What I would say, hurt.
Yeah.
Yeah.
It's like it needs to be painful.
Yeah.
So if I walk up to Mr. Hardy here, give him a little shove, and he says, "That's that all you got? I barely felt that." Is it an assault even though it didn't hurt him?
Well, it depends.
For the record, if I shoved him, he would feel it.
Yeah. Well, I guess intention also could play a part in the severity of it.
Okay.
So if they're coming at you like aggressively and shoving you, then I classify that as assault.
Now let's say I'm trying to walk through here. I'm trying to leave. I'm sick of this trial. I'm leaving. Mr. Hardy here is in my way, and I just give him a little shove out of my way. Is that an assault?
No, I wouldn't say that.
Okay. Even though he didn't want to be shoved, he didn't like that I shoved him, it's not an assault. Juror number 6, what about you? How serious does something need to be an assault?
I believe there's a lot of levels of assault, but any like use of force or taking a something like mine to someone.
Okay, so you're using harm. I don't have to prove that harm was caused. Are you okay with that? So going back to Mr. Hardy's, usually if I have an intern is even do that. I don't have an intern with me today, so I'm beating up Mr. Hardy. Let's say I just he gave me a dirty look. I just kind of give him a little backhand slap like that. Is that an assault? Yes. Now go back to the previous example. I'm trying to get out. I'm sick of this trial. It's too hot in here. I'm on my way out. This guy's in my way. I give him a good shove out of the way. Is that an assault?
I believe it's assault.
Juror number 7, how about you? Same question.
Same question?
Yeah.
I wouldn't think shoving them out of the way was an assault unless it was resulted in injury.
Okay, so an injury is something that's important to you for an assault. Okay, now let's say give me a dirty look, and I'm done with him. I'm over it. I just slap him right in the face, right? He's not injured, right? It's not even a red mark. Like I slapped him, I made a nice pop. Is that an assault?
You have no time to.
Okay. Okay, but when I pushed him out of my way because I was leaving, I didn't have the intent to assault him. Now, juror number 1, back to you. How serious is something need to be?
I thought that it was any physical contact.
Okay.
But maybe not like an accident, like if you trip and fell.
Okay. So if I opened that door into myself earlier. So if I open that door into myself and I fall down right into Mr. Hardy, that's not an assault. That's just an accident. That's an intention. Okay. Now, just for the group, back to my example of, I already asked a couple of you about it. Is there anyone who has not spoken on the example? I'm leaving the room. This guy's in my way. I push him out of my way. Is there anyone else who does not think that's an assault? Show of hands. Okay, perfect. That's all the questions I have. I will yield the floor.
Good afternoon. Once again, my name is Joseph Hardy, and I'm going to be representing my client here, Mr. Maurice Gary. Now, before we get started, is there any, raise your hand if you are actually happy to be here in this time forward? No hands. done this a lot, and there's very rarely any hands. Well, that's good news, because the best way to not be a juror today is to speak up, because we are going to be asking you questions, as you had already answered, with the prosecution here, to try and see where you stand on certain issues. Now, I'm going to ask this question to all of you. As Mr. Gary sits here next to me, does anyone here have any idea if Mr. Gary is innocent? Juror number one, or innocent or guilty? Juror number two, juror number three, 4, 5, 6. If someone is simply charged with an assault, does that make you more likely to think that they're guilty? Show of hands if that is something that you believe. All right. Juror number 5. What about being charged with an assault makes you think that this person will be more likely to be guilty?
So unless I'm ignorant, there has to be a reason to be charged with something. So like police would call and documented report on it, and that's enough for me to believe that they could potentially be guilty.
So right now, before hearing any evidence at all, once again, none of the statements made here during this voir dire or evidence. Right now, you believe that there's a higher likelihood that Mr. Gary is guilty
than any other person, yeah.
Okay. Do you believe that you could view the evidence fairly and put this bias aside? Does everyone here believe that they can look at the evidence presented here today without bias and come to a reasonable conclusion? Now, we're going to get into physical confrontations here, and I'm going to go down the line. I'm going to start at the opposite end this time. Do you think that every physical altercation has to have an aggressor and a victim, or is it possible for there to be more of a mutual fight where both parties are equally at fault? Is there always an aggressor and a victim?
Raised a bunch of boys. I think you can have 2 aggressors.
Juror number 6.
I think you're good.
Juror number 5. 4, 3, 2. Now I'm going to ask a little philosophical question, and with this question, I understand that you may not have a position on it, but of course, if you don't feel like that you have a position on it, or you're not really sure, just feel free to say that, because you are only looking through honesty. Now, in your start at the opposite end here, juror number 1, do you believe that it's worse for an innocent person to be found guilty and punished, or for a guilty person to go free? Which is worse in your mind? Juror number 2. Worse for an innocent person to be found guilty. Juror number 3. Same. Juror number 4. Same. 5. Same. Juror number 10.
I think they're both terrible and have horrible consequences.
Absolutely. Thank you for your honesty. Now, let's say in a hypothetical that the prosecution doesn't present a case, doesn't present evidence. Okay. Now, of course, he's going to do so, but entertain this. If he were to not present any evidence to overcome this burden that of the presumption that Mr. Gary is innocent, what would your verdict have to be? If the
There's no evidence.
yeah, so So what would your verdict have to be if the prosecution did not present the case? So what would your verdict have to be?
I couldn't hear the answers. We have fans going up and everything that's stated must be heard on the record. So can you go back to, it would be juror number 5.
Innocent.
Not
Thank you so much. And last question, and this gets into reasonable doubt. Now, reasonable doubt, there's no set percentage or anything like that that the prosecution has to overcome. It's merely making a decision in which any doubt that you have that's reasonable within your mind is overcome. Okay, and that is the only way that you would be able to find Mr. Gary guilty. Okay, so I'm going to start at the opposite end here. If you believed that there was a percentage that you would put on, that you would have to believe personally to yourself in order for this reasonable doubt to be overcome, what do you think it would be? Because with the understanding that 100% certainty, is very rare, if not impossible. But what percentage certainty would you think that you would have to have in order to overcome the burden of finding him guilty beyond a reasonable doubt?
I've never considered that, so I think it would have to be to say that beyond a reasonable doubt. 7%.
70%. Right. Juror number 6, same question.
I think like 80%.
80. Juror number 5.
I'll be like 60.
60.
60.
60. I'm sorry, 80. Juror number 2. 75. I have no further questions.
Just have to go over your instruction in response to it. And particularly, I think it was juror number 5, you said that you believe that because there was a police officer or police report and a charge that it was more likely or likely that the defendant was guilty, more likely than any other person. So I'm not sure you understood this jury instruction. So I did read the complaint, and there is a jury instruction that says that you should clearly understand that a complaint that I have just read is not evidence. A complaint is read in every criminal case so that the defendant and the jury can hear the charges. You must not think it is evidence of his guilt or that he must be guilty because he has been charged. Is that clarified?
Yeah.
So I'm just trying to make sure you understand that just because he's charged doesn't mean that that's evidence of his guilt. Okay, very good. Okay. Any challenges for Tom?
No challenges for council.
We would have one challenge for cause regarding juror number 5, just because even though he did state that he felt that he could put his bias aside, he did admit to showing a bias, and just according to MCR 2.511D, and that's subsection 2. It is grounds for challenge for cause to show that.
What was the bias?
Believing that he'd be more likely to be guilty simply from the fact that he was charged.
I think we just clarified that though. Is that your belief?
I understand the difference.
Okay, so I don't know that we've established a bias. think it was just a misunderstanding of the jury instruction. But I will allow you to further voir dire him if you believe that that has not clarified that.
I'll withdraw my challenge.
Okay. Any preemptive?
Yes, Your Honor, the time that people would think excuse juror number 7.
You said number 7?
Yes.
Thank you, juror number 7. You may be excused. Any further preemptory for you at this time?
Not at this time, no.
Okay, any preemptory for the defense?
The defense would like to thank and excuse juror number 5.
Juror number 5, you may be excused. I'm going to replace seat number 7 with Worry and Molitor. And juror number 5 with Rachel Hatt. You can continue your voir dire.
Okay, 2 new people. Sometimes you just have 1 new juror, and just all of them on hot seat. So that is 2 of you this time. We'll start with juror number 5. You're a financial specialist. What kind of work do you do in your specialty in finance?
That's spreadsheets. Pay bills.
Okay. We're rating your, there's a specific word I'm looking for. If you were to rate how well versed you are in Microsoft Excel on a scale of 1 to 10, where would you put yourself?
7.
7, nice. I put myself in like a -2.
You can Google most things at this point.
True. And your spreadsheet looking, how do you enjoy that?
It pays the bills.
Pays the bills. How long have you been looking at spreadsheets professionally?
Since I graduated high school,
Yeah.
so. Years.
Great. I mean, it must not be too bad if you're staying there for 14 years.
It allows me to do the things that I like to do outside of work, so.
What kind of things do you like to do outside of work?
Garden, grow flowers, hang out with my family.
Have you ever been on a jury before?
No.
How do you feel about possibly being on one tonight?
Take it or leave it.
Take it or leave it? Okay. Now, juror number 7, you are retired. Congratulations. Go green, by the way. What did you do before retirement?
Research with the USDA, chicken research.
Chicken research. What did you learn about chickens?
Well, there are a lot of diseases that you cannot pinpoint to one gene. There's multiple genes that cause chickens to get diseases. And they're really not right.
They're not bright animals.
The brains are really smart.
Okay, so they have diseases that are hard to pinpoint and they're not smart. All right. Did you ever find out why it crossed the road?
Good question.
I'll be here till Thursday. Have you ever been on a jury before? How do you feel about possibly being on one today?
Well, not really happy because my dogs are at home by themselves in the house. And there's no one to let me. But other than that, if I could go home and let them out, I'd come back and.
You know, there will be a lunch break. How long does it take you to get home?
15 minutes.
So you should be able during the lunch break to dart home with the dog out. Yeah. So, yeah.
But other than.
Okay.
I'm just, yeah. Wasn't expecting to be doing all this today, so, yeah.
But yeah, knowing that you might have a chance to run home and let the dogs out, does that make you feel a little bit better?
Yeah.
Now back to juror 5. I guess first off, for both of you, are either of you familiar with the Kristen Community Center?
I just know the thing.
You know the name?
We used to donate eggs to guy that did work with Kristen Ray. Because we could donate eggs, but it couldn't be to homeless, to to give away because they had degraded, but they said degraded. But if you're cooking them for homeless people, that's fine. So he
Okay.
took it to South, I think the one on Miller or Washington, I
Okay.
think he was associated with, but I know of this two buildings.
And are you able to put aside any knowledge you have of Kristen Ray?
Oh.
Now, juror 5, how serious does something need to be to rise to the point of being assault?
Any harm done intentionally.
Harm done intentionally, so it's about the outcome rather than what you did.
I mean, I think all the examples that you said earlier, a slap, push, punch. Is considered assault.
Okay, so those are just having someone put my hands, so someone putting their hands on me, that is.
Yeah.
Okay, understood. And juror number 7, what about you? How serious is it?
Same thing, and if you don't want to be touched, anything that touches you is kind of an offense. Up to a point, if you don't retaliate and you walk away, then that's cool, but it goes both ways. I mean, once something happens and you retaliate, then you kind of both. You know, there's consequences of both. But
So
I don't know to what extent, it's
Yeah.
kind of hard to know, what a push does versus, someone hitting you, obviously. Is a difference,
Okay.
you know?
So let's go back to the example of I'm sick of being here. I'm on my way out. You can see he's blocking me and I shove him out of my way, right? That shove, is that an assault?
It's kind of not, it's against what he agrees, and, he didn't do anything to do it.
So that
you
would be
kind
an
of are
assault.
guilty because you did something to him that he didn't antagonize you to do it. He's just sitting there, innocent, so.
Now, let's say after I shove him out of the way, he gets up and he just clocks me in the face and just really beats me up. All right. And then let's say I'm then charged with assault for shoving him out of the way. Would you be willing to find me guilty of assault under those circumstances?
I don't know if I'd call it assault, but you're guilty because you instigated the problem, you did the problem.
So even though he proceeds to really beat the crap out of me, I
There's
still
levels.
am.
I mean, he's coming back at you for something you did. So you're both guilty, but then you have to weigh, what like felony versus, misdemeanor versus, you gotta.
And you understand that this is a misdemeanor.
Yeah.
And you also understand that, well, we have a very well qualified judge over here who, if there is a guilty verdict, will decide the sentence, so you don't have to worry about that.
Exactly. Yeah.
All right, thank you both.
Good afternoon. No, I know that you were listening before, so a lot of this may seem like I'm repeating myself, as I am, but wanted to get your thoughts on certain things about the criminal justice system. First, juror number 5, as Mr. Gary sits here, do you have any idea whether he is innocent or guilty?
No.
Juror number 7. And do either of you believe that just because someone is charged with a crime that necessarily makes it more likely that they'll be guilty? No.
Not guilty, but if he's in, I kind of think something happened. Whether or not, you'd have to listen to the evidence to know guilty or innocent. That's what the trial is for. But something caused him to be brought in. So I have to hear about that.
So what you're saying is you're just willing to let what the evidence.
Yeah, oh yeah, because I mean, my background is forensic science at MSU, master's in the back, so I know, I've got to have the evidence. Yeah.
Right. Now, I'm going to ask the same sort of philosophical question again. So do you believe that it is worse in your mind for an innocent person to be found guilty and punished, or for a guilty person to go free?
I think both of them are bad, but if I had to rate it, I'd say an innocent person being guilty is worse.
I would say
the same. Now, juror number 5, do you think that every physical altercation has
an assaulter and an assaulted, or an aggressor and a victim? Or do you think that there are certain scenarios where it can be a mutual fight where both share some culpability?
Yeah, and the evidence would prove hopefully both, that was to both sides, two sides.
So no further questions.
Challenges for cause.
None from the people.
None for cause.
Any preemptory.
None from the people, Your Honor.
The defense would like to thank and excuse juror number 4.
Thank you. Previously, I asked you, did you have any other preemptors? And you got a preemptor or someone who was already on the panel during that time. Otherwise, it's considered waived as it relates to those and only able to preempt the new one. So, any other preemptors?
None.
Or was that your cause, actually?
No, that was peremptory. That was
You didn't have any preemptors?
Correct.
Okay. And that was juror number 4. So what that means is you are satisfied with whoever's here now. That's why I'm asking any other preemptors.
Yes, sir.
Okay. Okay, we will replace juror number 4 with Carrie Ross. Okay, you can wait.
All right, now we have a hot seat. Juror number 4, looks like you work in HR with the title People Experience Specialist.
Correct.
How do you like working in HR?
I love working.
Or what do you love about it?
I just love helping people.
Yeah, you love getting all the hot goss, right?
No. That's not usually, actually, that's the perception. That's not usually what we're dealing with.
Okay. How long have you been working in HR?
15 years?
Have you ever been on a jury before?
No, but I have been in this stage.
So you've
here.
made it this far.
Yeah.
Okay, this is your chance to take it all the way. How do you feel about the possibility of being on a jury today?
Okay.
Yeah. Now, do you have any familiarity with Krista Ray?
I've been to events there before.
Are you able to put aside any knowledge you have of them?
Yes.
And last question, nice, quick and easy. How serious does something need to be in your mind to be an assault?
I would say it just depends on really like stumble into somebody and they fall and get hurt. I don't think that's assault. You are intentionally, physically interacting with someone, like
You're intentionally making physical contact with someone and being aggressive, and it's an assault.
right, in a negative manner.
Okay.
Like someone's hugging you, you don't want them to. I mean, that's not assault.
So if I go up to Mr. Hardy right now and I give him a hug, that's not an assault.
No.
Okay.
Unwanted contact.
But if I give him a shove out on my way, that is an assault.
If you're intending to be aggressive in your shoving, I would say.
What does it mean to intend to be aggressive?
I mean, if you're just trying to get through and they're in your way and you accidentally shove them out of the way, but if you're intentionally shoving someone out of their way in a aggressive manner.
So let's say I'm on my way out. right? I don't care about this guy. I have no ill will towards him. He's in my way. And I intentionally push him out of my way, knowing that common sense tells me he probably doesn't want to be pushed. Okay, so even though I'm not thinking I want this guy to be harmed or embarrassed, I intentionally push him out of my way so that I can keep going. Is that an assault? Okay, so it's a little nudge that's not an assault, but if I really just toss him out of the way, then it's an assault.
I would say that.
That's all the questions I have.
Good afternoon. Just a few more questions for you. So, as Mr. Gary sits here, do you have any idea whether he is innocent or guilty?
No.
And do you believe that just because he has been charged, that makes it more likely that he is guilty?
No.
What you're saying is you're willing to just look at all the evidence objectively, fairly?
Yeah.
Now, do you think that it is worse for an innocent person to be found guilty and punished, or for a guilty person to go free?
I think an innocent person to be punished.
And do you think that every physical altercation has an assaulter and an assaulted, or an aggressor and a victim? Or do you think that some physical confrontations are situations where both sides share some sort of non-blame?
There can be instances when both sides share blame.
And for a hypothetical here, if the prosecution were to not present the case at all, and just with the information you have now, what would your verdict have to be?
Innocent.
No further questions.
Challenges for cause.
No, Your Honor.
You?
No.
Any pre-entry?
Yes, Your Honor, the people will thank and excuse juror number 4.
Thank you, juror number 4. You may be excused. Mark Douglas Short. You can proceed.
Welcome to the hot seat. This is my questionnaire. You work at Goodwill. How long do you work at Goodwill? 8 years. How do you like it there? What is good and what's not good?
Can you hear him?
I cannot hear him.
You have to speak up, sir, because we can't hear you. Yes, because we have these fans, so it's drowning out the sound.
It's good when I can help people find stuff that they need more prices. That way they don't pay $200 for a shower trailer and get $10. And bad is when people yell at your face because they don't like the price.
Bad when people yell at you if they don't like the price. Gotcha. Have you ever been on a jury before?
Yes, I got to the end of the thing.
So you were excused as the alternate. How'd you feel about getting excused as the alternate?
Happy it was over, but at the same time, at the end of the day, just excused and hopefully for someone.
And how do you feel about possibly being on a jury today? And are you able to put aside any knowledge you might have of the Cristo Rey Community Center?
Yes.
And then finally, how serious in your mind does something need to be in order to be an assault?
Basically, if someone gets, if Partially intent, partially.
What if no one gets hurt?
Then probably people.
So if I come over to Mr. Hardy and I give him a big shove and he's not hurt, is that assault? No. Okay. Right, that's all the questions I have.
Good afternoon. Just got a few questions for you. First, as Mr. Gary sits here, do you have any idea whether he is innocent or guilty? Do you believe that being charged with a crime makes it more likely that the person is guilty? No. So you're willing to look at all the evidence objectively and fairly? Yes. And do you believe that every physical altercation has an aggressor and a victim, or an assaulter and an assaulted, or are there some situations where it's more of a mutual fight?
I think basically it can be one for the other or both parties.
And finally, do you believe it's worse in your mind for an innocent person to be found guilty and punished, or for a guilty person to go free? No further questions.
Challenges for cause.
Your Honor.
No.
Any injury.
Your Honor, the people would thank an excuse Sheriff Ford.
Mr. Sheriff, for you may be excused. Kenneth Eugene Richardson.
Okay. Welcome to the hot seat. I see you work for General Motors. You work at the plant right down the road from here? No? Where do you work? Okay. How long have you been working for General Motors? But we're gonna need you to speak up a little bit.
15 years.
And how do you like your General Motors?
I love it.
What do you love about it?
I like working with people.
Great. And have you ever been on a jury before? How do you feel about being on one today?
I don't too much care for it because I feel that I don't like being in a position of judging people because of the simple fact that in someone's life in my hands, one decision that I made, I had, so.
It's difficult for you to feel like you're judging another person. So you're going to be instructed not to consider a possible penalty. Is that something that you think you can do?
Again, I have an issue with how can I judge someone?
I guess, my question is, are you able to follow the instruction not to consider the penalty that the person could face? And you say you don't feel comfortable judging a person. Does that have you feeling like you would not be able to find someone guilty?
Not necessarily, but it would be difficult because of the simple fact that my religious beliefs, judging people, shouldn't judge.
Would it make you feel better if I told you I'm not asking you to make any judgments on his character? I'm just asking you to assess whether someone did or did not act. Does that make any difference to you at all? It's okay if it doesn't make any difference to you. Not sure. Now, I guess, your religious beliefs and your concerns about passing judgment, do you think that those would interfere with your ability to be a fair juror?
No, I don't.
So you think you can be a fair juror?
It's not so much, I guess it's the fact of what I may say or what I may choose to believe or whatever may affect someone's life. So that's what.
Okay. All right, thank you for sharing all that.
Yes, sir.
And I guess same question I've asked everyone else. How serious in your mind does it need to be to rise to the level of assault?
Someone puts their hands on the wall, ask them to stop to me.
Okay. So the example of me.
Soft.
Yeah, okay. No further questions. Thank you.
Mr. Hardy.
No further questions.
Any challenges for cause?
No, Your Honor.
Any for cause?
None for cause.
Any preemptive?
No, Your Honor.
The defense would like to thank and excuse. juror number 4.
If juror number 4, you may be excused. I ran out of spaces for juror number 4. LaWanda McLean.
Okay, Ms. McLean, welcome. We officially have a revolving door. We almost always wind up with one. That said, Mr. Hardy and I have both exhausted all of our peremptory challenges. So if you want to get out of here, you got to say something real crazy. Okay.
I feel the same way you wanted to say.
Okay. You feel uncomfortable passing judgment on another person?
My belief.
And does it make you feel better that we're not asking you to pass judgment on his character?
No.
Your I guess, aversion to passing judgment, would that keep you from being a fair jury?
Yeah,
How would it keep you from being fair?
because I wouldn't do it. I'd probably be the one just like. And I just couldn't do it.
When you say you couldn't do it, you mean like?
I don't want to do it. To pass judgment on somebody else. I just don't want to be in that situation to even have to do it.
If you are impaneled and placed on this jury, yes, you don't want to do it, but if you're placed on this jury in order to do it, would you do it?
No.
No, you would not.
No.
I guess. To be clear, when you say no, you're saying you would defy the court if you see on the jury.
Well, I'm not saying I defy the court. I'm just saying my belief is, my religion is, I just don't want to pass judgment on anyone.
So is it, I guess what you're saying, your religious beliefs keep you from being on a jury?
Yeah.
I guess what in your, without probing into your beliefs, what does your religion teach would be the proper procedure if someone's accused of a crime?
Well, I believe God is the judge of all people. What I believe.
Let me ask you a question. What is your religion, if you don't mind me asking?
What is my relation?
Your religion?
I'm a Christian.
Okay. And so just based off your statement, let's hypothetically, someone breaks into your house tonight and they steal something valuable from you. The police arrest them. Would you take the position that they should go free because God will be the judge?
Maybe.
Maybe?
Yeah.
Let's say you walk out here because let's say I release you and you go outside and someone who else is leaving court and they're upset and they punch you in your face. And
That's
he, get-
assault.
yeah, exactly, and he gets arrested for doing so. Would you want him to be prosecuted for an assault, or would you want God to judge?
Well, that's different.
It's now it's actually the exact reason why we're here is for an assault.
Right, but that's, it just don't seem the same to me, being the one to judge.
So I guess for us to.
No, I'm trying to understand if that's your religious belief, because I'm a Christian as well, and I'm not familiar with what reference you're making that you cannot serve on a jury. And my understanding of the scriptural reference you're using is you're not to judge someone else's sins or their character. But this is not the purpose for which you're called to serve on a jury. And so to serve on a jury is to determine the facts of a case based on the standard, which is that they are supposed to prove the facts beyond a reasonable doubt. And we require fair and impartial. So I am trying to understand if you're just saying something crazy so that I can remove you as if he suggested, or if that's a sincerely held belief. And I don't believe it's a sincerely held belief based off the way your statement changed. When I asked you if someone has punched you in your face outside, would you take the position that you want God to judge them? Or would you want that person prosecuted you for punching you in your face as you're trying to get to your phone?
I would want them prosecuted.
So that means you would want them to go through the same system that requires fair and impartial individuals.
Well, I don't think they'd have to go through jury.
But they have the right, the law says they have a right to a jury. Correct?
I thought that's just when you do a felony.
No, that's not.
Any crime is.
All crimes.
No, I don't know.
Be that as it may, I'm going to remove her for cause. I'm removing her.
Okay.
Any objection?
No objection.
You may be excused.
Thank you.
Sophie and Rovna or the Rovna? You can proceed.
All right. C4 continues to evolve. I see you're a dental program coordinator. I have a confession to make. I don't floss. I haven't flossed in a long time. Don't think so.
I don't even know anything.
No, I don't get a lunch break. This is why.
True. Okay. Obviously, we no longer have any peremptory challenges. We don't have the ability to just, remove you because we don't want you to be on this jury. Is there anything you want to add on to that you feel strongly about that you've heard?
No, but I would say that I'm probably maybe one weird person here, that I do want to do this. Because I'm very interested in the process and I never have seen it before. And I am very interested in the legal system, how it's going to work.
Is it okay with you if I ask where you're from?
Russia.
Where you are?
Russian.
Okay, I used to work with someone named from Latvia. It's kind of a similar way of talking. Very cool. I have a lot of people who do want to be on the jury. So that's not unusual. And so I think that you feel comfortable. We had 2 in a row who don't feel comfortable feeling like they're judging someone. Do you understand that I'm not asking you to like judge his character?
Yes.
That's all the questions I have. Thank you.
As Mr. Gary sits here right now, do you have any idea whether he is innocent or guilty?
No.
Do you believe that he's more likely to be guilty just because he was charged?
No.
Do you believe that you can be fair and impartial when examining the evidence? Questions?
Any challenges for cause?
No, Your Honor.
Well, we have jury. And so the remaining of you, thank you for appearing today and being prepared to serve if called on. And remember that if you were to find yourself in this situation, and it could happen to anyone, that you find yourself in the situation where you're charged with a crime, that you would want someone fair and impartial to be willing and ready to hear the facts and make a determination. So the remainder of you are free to go. I'm going to give the jurors some brief instructions. I'm not going to go into the jury instructions. I'm going to let them go to lunch so they can come back by the top of the hour. But the remaining you can follow the court officer. And then for the jurors, I am going to release you. You have to be back by 2 o'clock. I have a 1:30, some 1:30s I need to handle anyways. And there'll be some further instructions. You will receive a sticker, or you should have received the sticker. That sticker should be placed on you while you're moving about so that you can be identified as a juror. There is a room back here that's designated just for the jury. So no one else is allowed in there. There is a restroom in there. You're not allowed to speak to anyone connected to this case. And as it stands, you know nothing about the case or who's connected. So be very cautious about speaking with people because you may inadvertently speak to someone. And even if it's not about anything relative to the case, it could give the appearance of something improper. And so we don't want that either. So if any of you were to determine or to witness someone violating these orders that I'm giving you now, you would just report it to my court officer when we return. So if you want to leave any of your things locked into the jury room, you're free to do that while you run and grab whatever you need to grab, and then be back here in about 37 minutes, okay? All rise for the jury. You can be excused.
Okay.
Oh.
And I need the files, please.
Oh, it's also, okay.
And, oh, let me send these. Oh,
You heard
man.
it?
What's that? Good Lord.
I thought I was before.
I don't need to do that. There you go. Snatch. Yeah. There. This is the state of Michigan versus John Heather, 24-01274.
Ross Marchino for the people.
Thank you.
Assistant Public Defender Justin Straub on behalf of Mr. Heather, who's standing here to my right.
Okay, today was the date that was scheduled for hearing on the probation violation. The allegations I see are that the defendant failed to submit to random urinalysis back on the 27th of May, and that he has failed to obtain employment and provide evidence of that employment. And you said we will not be having a contested hearing?
That is correct, Your Honor.
He's pleading guilty to those violations?
Yes, Your Honor, with an explanation.
Raise your right hand. Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
You can put your hand down. Okay, and you understand your right to have a contested hearing and your right to have proofs put on the record to establish whether or not you have violated the terms of your probation.
Yes,
And you want to waive your right to have that contested hearing?
I did.
You want to plead guilty to the violations that I just read?
Yes, ma'am.
Anyone threatening you to do that?
No.
Any promises if you plead guilty?
No.
As to the allegation that you have failed to test on May 27, 2026, how do you plead?
Guilty.
And as to the violation that you failed to obtain employment and provide proof, how do you plead?
Guilty.
Factual basis.
Mr. Heather, is it true that you were sentenced to a term of probation?
Yes.
And were you ordered during that probation term to complete your analysis?
Yes.
Okay, and did you fail to do that? I did not catch that date. On the 27th?
Yes.
And you were provided ample notice of that, right? You knew that you had to do that?
I had to do it twice a month. I was told yes.
Okay. And you failed to do that, is that correct? Okay. And then you were also ordered to obtain employment, is that correct?
That's right.
And you have failed to do that as well.
Yes.
Do you think that's
Questions from the prosecution?
No, Your Honor.
Satisfied with the factual basis, I will accept your plea upon your plea to be pleaded voluntarily and intelligently made. The recommendation from the probation officer states here, defendant's overall attitude is fair, but overall progress is poor and acceptance of responsibility has been poor. Our defendant continues to not test us directly, even with consideration given for transportation. Still has not obtained employment. It has been over a year since his probation started. The defendant was offered an opportunity to test at Aberhole, but declined. What is the explanation that you believe I should hear?
Your Honor, I just wanted to point out that Mr. Heather has been working on obtaining employment. I do believe he has an interview coming up later this week. I think he was
Within 3 business days, including today,
Where?
McDonald's for a high-level management position.
Why is it taking you so long to get an interview at McDonald's?
I was passed over several times because of my resume. I was deemed overqualified.
To get a job anywhere?
Well, I do believe that the retail places that I considered saw that there was a retail fraud on my record, so they passed me over for that reason.
Okay.
And then, yes, the fast food industry have been passing me over for, I hate to say this, but lesser qualified people.
Okay.
Now that I was told that, I did pursue an actual manager at the store and kind of cornered her a little bit and said, I have all this experience, why are you denying me? She talked with me for about 5 to 10 minutes and immediately asked me to go and put her name on my application. As soon as I did, I received this 3-day window where they're going to call me back. She said, I'm almost guaranteed a job.
Okay, so you don't have an interview. You are expecting a call for an interview.
Yes, within the 3 business days, yes.
Okay, so that means you just did this week.
Last week, right? And I amended it Monday, so yesterday.
And explain to me why you don't think you need to test when you were ordered to test.
So, to be honest with you, Your Honor, at Pat's, I was told by their people that I was going at a once a week rate. And I talked to Joe, I had several correspondences with him where I had already taken 2 tests in a month. And I said, okay, this is the 3rd time, Joe, what's going on? He's excused me every time from that. And this time I had taken the first test in May, I believe it's May is the question. Yes, May. I had taken the first time in May. And when I met with him, he told me to keep doing what I was doing, to just trust him. If anybody was going to violate it, his words, he was going to violate, not Pat's. So I trusted him to let me know when I was supposed to go in.
Because Pat's can't violate you.
Right. So I trusted him to give me the next day to go in May. He did not. I had no communication with him. And when I finally found out on the 4th.
No, he said that you still haven't been testing. He broke this in June.
No, I taken both tests in June. I have one on June 5th and one on June 29th. As a matter of fact, the one on June 29th, he wasn't.
Can you call his probation officer?
He wasn't answering my emails, so I just took it upon myself.
I'm gonna have him come up here so you could say that to his face.
Okay. Sure. Your Honor, may I sit down?
Thank you. You're off to come. You're still on the record. No.
No.
If you're gonna be going to work at McDonald's, you better start training now.
I understand. I'm just, yes. A little nervous to be here, that's all. Can't be working on my feet. So I'm nervous.
You can come over here. He's going to grab the file from downstairs to Jim. Good morning, good afternoon, Mr. Sumter. Okay, we're on the record presently for Mr. John Heather. He's entered a plea to the violations, but by way of his explanation, he said it's your fault. And he said that you promised him that you would make him aware of his test, and he didn't hear from you.
My response to that is, I've gone through this with Mr. Heather for like the past year, probably. He knows where he was supposed to be testing. Last time we were in court, Judge Ball, in your absence, made it very clear to him that he was to follow my directive in testing. He needed lab confirmed tests that met the court's criteria for the urinalysis. And he just decided to test whenever he wanted. That's why we're here. He also, I was lenient in some aspects, allowing him to maybe test the next day, whatever the case may be, but the test that we're here for on the 27th, I didn't hear from him again until into June. Offered him an alternative place to test. He didn't want to take up that option, so he decided to test at Compass Testing, I believe in Mount Pleasant, 2 weeks after. So,
It's, oh, he's not telling the truth.
I tested at Pat's the next day.
So you tested at Pat's on the 28th?
That's correct. Yeah,
On the
that's-
28th?
No, on June 5th. the
No,
day
you
after
were
we
ordered to
spoke.
test on the 27th.
Oh, I thought he was talking about until June. I went to Compass. No, that's not true. I went to Pat's.
You went to Compass in June.
In June, the last day of June, like
Right.
29th or the 30th, but I went to Pat's on the 5th or the 6th for your order.
It's not the day after the 27th.
I didn't
That's the
say it
violation
was.
We're here for.
I didn't say it was, but you said that I tested at Compass only. That's not true.
You didn't test on the 27th, correct?
No, that is true.
Okay, and you did not test again after that until June?
Until I met with Mr. Something, I was under the
In
assumption,
June 5th?
I was under the assumption that, again, it's my fault for assuming. I should have been more.
You under assumption of what?
That I was supposed to hear from him when I was supposed to go and test. As a
Well,
matter
you
of
knew you were
fact-
supposed to test on the 27th.
No, I didn't.
Why would you not know that you were supposed to test?
As a matter of fact, Mr. Sompic told me that I was released from testing at Pat's until further notice per email. One of his emails said
You have
that I
an
was.
email
Yes, I
before
surely do.
May saying that you were released from testing?
I sure do.
You have the
I
email?
have the email thread, Your Honor. Thought I might need.
This
Thank
is
you.
June 12th. I advised him he could go to AverHealth if he wasn't comfortable testing at Pat's.
June 12th?
June 12th.
No, we met on the 4th.
No, I'm looking at an email.
Oh,
from
when you
June
told me I
12th.
could go to the other place, yes.
Correct.
That's in Flint.
Okay, I've heard enough. Anything else?
No.
Okay. 30 days Ingham County Jail, discharge you unsuccessfully. It's been over a year. I'm not gonna keep going back and forth with you about what your requirements are. And I had another judge in my absence, after you had already violated by drinking alcohol while on your probation, tell you that this was the last time and that you would do 30 days. And a promise is a promise. Best wishes to you.
I get my phone? Where's your phone? Here you go.
Okay, we'll discharge you unsuccessfully, refer the fines to collections. Would you like to sign? Thank you. Also, thank you. This is the state of Michigan versus Joseph Johnson. And this is 24-01571. Appearance.
Ross March, meet up for the people.
Assistant Public Defender Joseph Hardy on behalf of Mr. Joseph Johnson, who is standing here to my right.
Mr. Johnson, I haven't seen you in quite some time. I'm doing all right. How are you doing? I can imagine you're not doing the best. There's no way you can be doing the best if you're wearing a blue jumpsuit from the jail. And last time I saw you was in September.
Yeah, I had stuff going on like with my son and stuff like that. So
Yeah, I had stuff going on too, because the last time I saw you, I was here. And then I had a lot of stuff going on. And all I asked you to do was bring me 40 hours of community service and I will discharge you. That's all I asked you to do back in September. And that was after I had extended it multiple times for you to give me the community service. And then that was also after I had already told you that even though I told you exactly where you were going to do your community service, and you decided you were going to do it someplace else. You first told me the Bishop Singleton was going to call me. I didn't ask Bishop Singleton to call me. I didn't even tell you to do any community service with any bishops. And I made all kinds of allowances to try to get you to comply, just so that we can get you on track. And I mean, this started in 2024. It's more than halfway through 2026.
I got a paper showing that I did 16 hours, so like 100%. And I swear I end up having all three of my kids. I asked the CPS lady to come here today, and my son is up at the hospital still. He's on the machine right now, and I was asking people to come today because it would have made it a lot better. We've been able to explain to you like my son's been struggling hard. So
what does that have to do with your community service that you were supposed to turn in 2025?
He's been dealing with this since 2025. Nobody helped me. Nobody been helping me out there.
No, because if you think I'm not familiar that you have other things going on within the court system, I'm very familiar. So you had time to do other things. You weren't by your child's bedside 24/7. If you had time to do that, you had time to comply with my order to complete the 48 hours of community service that I ordered you to do over a year ago.
But I don't always be like, for that situation, I don't do that like on a daily.
I'm not asking you if you do, but what I'm saying is you're trying to make me believe that because of what's going on with your children, you were so diligent and attentive to your children and you never left them, so you never had a moment to get away and bring me proof that you did your community service. That's what you're trying to tell me.
I promise you, not for this last time.
What last time?
The last time I seen you, I really mostly was with my kids. I wasn't in no trouble, and I don't have for the situation you just heard about where you end up.
What situation I heard about?
About the little drinking situation.
The little drinking situation?
I believe what he's trying to say is that there's been a lot of things that have caused him, both physical and emotional, mental turmoil throughout this time that has gotten him off track. He mentioned the issue with his children,
But also as this court is aware that, he was robbed as well. And I believe that when I spoken with him, there was.
I'm sorry, he testified under oath that he was not robbed.
No,
So
no, I didn't.
He's admitting to.
Tell him what situation you put me in.
Oh, Jesus.
He promised me.
I'm
that-
sorry, whoa. Because obviously Mr. Marchmina was, I believe, in the other courtroom during this whole ordeal. One second, sir. When was the allegation of robbery? On or about what date?
I'm getting that case pulled up. I think it was January of this year.
January of this year?
Yes, Your Honor.
It was January during the time when he told me he was with his children?
January 27th.
When that happened, I was with my children.
At the hospital? You got robbed at the hospital?
No, I've been staying at the hotel forever.
You got robbed at the hospital?
No,
you just told me you couldn't come up here and drop off your community.
Like,
You just told me you couldn't drop off your community service because you was at the hospital.
No, I was there.
I want to note that he said he's been at that hotel forever, but he testified under oath that he didn't even know which hotel I was talking about.
Hotel in general, but what you try to make me, okay, this is what he promised me. That when I had got a warrant, because he was supposed to tell y'all what was going on with me. When that whole situation, my phone got taken, my money, his shoes, this was all on camera. And I other stuff, but he promised me that I wasn't gonna go to jail, be around the
Your phone
same.
got taken and
Everything.
your
I was a
money.
victim of a situation. Then he said,
What's the situation that you were a victim of?
Like, whatever situation it was, but he's.
No, I don't know what that means.
And don't say I didn't say it didn't happen. I said that guy.
Are you talking to me? You don't talk to him.
Basically I was robbed and stuff like that.
So you were robbed? Is that a yes?
Yes, ma'am.
Okay. And so you were at a hotel that you were staying at? You were at a hotel
Yes, I was.
that you had a reservation and you were staying there?
I didn't have a.
Oh, again, you were not with your children. You were at a hotel. And there's surveillance of you at a hotel, not with your children, correct? So don't tell me that you could not drop off your proof because you were so inundated with being a dad. You know how many times I've seen your name run through here over the last year that has nothing to do with your children? Allegations of you being involved in things that you shouldn't have been involved in had nothing to do with you being with your children. Who is this person behind you that keeps raising her hand?
I'm his mom, Judge.
Okay, why are you raising your hand?
I was just gonna shed light on the situation about the hotel or robbery and stuff.
Oh, I don't want no shedding lights on the hotel or robbery, because only reason I'm bringing up that is because he tells me he was with his children and he was not with his children all the time. And to tell me that you were with your children every day and every minute of the hour is a bold-faced lie when we have surveillance that you were not with your children when you allegedly were robbed.
I didn't say I was with him that day.
No, you just told me that the reason why you couldn't drop off your stuff is because you've been so inundated with taking care of your children, and that's not the truth. It's not the truth. It's not the truth. And just as your mom could come in here and sit in here, she could have dropped it off for you. Or you could have had her sit with your children if in fact you were with your children all the time. But based off the evidence, you were not with your children all the time. You could have done it, you failed to do it. And this was something that I had extended and kept giving you extensions and kept giving you extensions. Do you know when I put you on probation originally?
Yes, ma'am.
When?
2025, I believe, May.
June 20th, 2024, you pled guilty. August 15th, 2024 is when I told you to do 48 hours of community service. So you're still not taking accountability. You're telling me that the reason why you couldn't do 48 hours, 48. Some of us work more than 48 hours in a week. I asked you to do 48 hours of community service and tendered that, and you did not do it in 2 years. Inexcusable.
Oh, I apologize.
How are we proceeding on the violation, which is that he admitted to drinking, as I believe the violation? Under oath in a courtroom down the hall?
At this point, after discussion, Mr. Johnson indicated that you'd like to enter a guilty plea to the violations for failing to provide proof of completion of community service, for failing to report to probation officer on February 11, 2026, and for admission under oath of drinking during the January 16th case.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, sir.
Okay. Do you understand your right to have a contested hearing? And you want to waive the hearing and plead guilty to the violations that your attorney just read off?
Yes, ma'am.
Anyone threatening you to do that? Any promises to get you to do that?
No.
Your attorney read off more violations than I see in here. Let's see here. Must be another violation.
Listen, can you please go change the door down?
Do I look like Biggie Smalls? Don't ask me to give you one more chance, okay? Did I give you one more chance? Did I give you a second chance? Did I give you a third chance? A fourth chance? So why would I give you one more?
Because I promise you, I will.
No, your promises have no weight here.
Okay.
You have no value in your word in this courtroom.
If I don't get it done, can you?
No, you're not gonna get it done. That's a wrap for that one. Let's see here. It was failure to appear. There we go. Okay. Looks like failed to provide proof of completion of community service, failed to report to your probation officer back in February. And then the admitting to use of alcohol while testifying in court. As to each of those violations, you're pleading guilty? Okay. And you were placed on a term of probation before this court again back on August 15, 2024. Is that correct? Is that a yes? Okay, and you were ordered to complete 48 hours of community service. Did you complete your 48 hours of community service? Okay. And then you were ordered to report monthly to your probation officer. Is that correct? And you failed to report to your probation officer, years probably since January. Is that correct?
I don't know if it's since January, but yeah, I know
It
it's
says
time.
you failed to report in February, so I'm assuming.
I know it's time to say I'll be off and all of that because I don't.
No, you didn't report since February. You must absconded since February. Correct. Okay. And then there was allegation that you admitted to using alcohol or about January 26th, or a lot, I believe is the statements you use.
This goes back to the situation he put me in.
The situation that who put you in?
Him.
He made you drink alcohol?
No, that's not. I'm saying like what I said.
No. We're not.
because
He's
this
not
is
responsible
gonna
for
get
you
more
drinking
trouble,
alcohol.
like,
He is absolutely not
That's
responsible.
not what I'm saying.
He is not responsible for you drinking alcohol, nor is he responsible for you saying under oath that you drink alcohol.
No, that's not what I'm saying. I'm saying like, there's no finesse for it.
Okay. As to that violation that you admitted to using alcohol, how do you plead? Okay. Any additional questions?
No, Your Honor.
That on factual basis?
Thank you. Mr. Joseph Johnson, is it true that you were placed on probation by this court for an attempted resisting arrest? Okay. Is it true that your probation agent told you that you had to provide proof of completion of community service hours? Is it true that you violated that order on September 8th, 2025? Is it true that you failed to report to your probation officer on February 11th, 2026?
Yes.
Okay. And is it true that you admitted to using alcohol under oath on or around January 27th, 2026, while you're testifying?
Yes.
Any questions, Mr. Martino?
No, Your Honor.
Before is satisfied with the factual basis, I'll accept your plea. I find your plea to be voluntarily and intelligently made. The recommendation from your probation officer says your overall attitude is good, but your progress is poor, and your acceptance of responsibility is poor. It says the defendant has called on random days to let the PO know that he will be turning in his community service sheet. Defendant has not turned in a completed community service sheet and does not report to probation on scheduled report days. Defendant's second violation for failure to complete community service. Defendant has been in bench warrant status since March of 2026. The recommendation is to terminate your probation status and impose a jail sentence. Counsel, you can address.
Thank you, Your Honor. This court has went through the various attempts that the court has made to allow him to get community service hours. We're not going to dispute the fact that he was given several chances to do so. What I would just say is that I do believe that a long stay in Ingham County Jail definitely serves as a wake-up call to a lot of people, my clients, other clients within our office. I do believe that, after speaking with him, that this is not something that he wants to go through again. With being in custody, with losing his freedom. Here, we would just ask that time that he has served, which I believe he was incarcerated in May, be applied. With him drinking and with the amount that he had stated that he had drank, I do think that he could be successful on probation with some increased monitoring for alcohol. I do think that by ensuring that he is sober, that a lot of these things could be alleviated. So we would request that his probation be continued with increased monitoring for substances and alcohol. And it's my hope that with this sobriety, that he can be successful in all the other requirements that this court has asked of him. I do believe that this past month and a half around has been sobering for him, and I do think that he can get back on the right track.
It's really concerning, sir, that you went from facing a felony, habitual offense, fourth offense notice on this case, to getting a very reasonable plea offer, a very reasonable minimal term of probation. I put you on probation for 6 months. Only ordered you to do 48 hours of community service because you said that you had a disability that prevented you from even being employed. Told you not to engage in any assaultive or threatening actions. I told you you were going to submit to preliminary breath testing only for 30 days. And if no positives, it would be revoked, and that you would do anger management. And you couldn't comply with any of those things. Not only could you not comply, you continuously find yourself in certain circumstances and situations that not are just concerning for someone on probation, but literally concerning for your life and longevity. You're a father. There are little people that should be able to rely on you, and you've not proven or demonstrated yourself to be reliable even for yourself at this point. And that's concerning. I think I shared with you in one of our previous hearings. You're a very nice gentleman, very nice looking gentleman, could have a very promising future if you applied yourself and did what was right. Made good decisions. First decision deciding, I'm not going to hang around these people that are getting me in trouble. Other decision, I'm not going to use alcohol because I'm confident you have a substance abuse problem as it relates to alcohol. I'm confident. But you haven't decided to make those decisions for yourself. And even from the time that you first appeared before me, which was only 2 years ago, to now, you've aged in your face. You know why? You're living a hard life. A life that'll put you either in prison or the grave. Who's supposed to support you, raise, and help your children if you're dead?
Mom said the same thing.
No one's saying this for shock value. This is the reality of the lifestyle that you're living. The only reason all these people are sitting here is not because we want to see you in a blue jumpsuit. It's because we really want to see you get on track so you can win, so you can stay out of trouble, so you can be an upstanding, participating, and contributing member of this society and community. So you can be a good father, which is your first order of business at this point because you've made children. So you can be a responsible, loving, caring son. Anytime your mother has to come and sit in a courtroom while you are in a suit was not what she envisioned when she birthed her son. You haven't chosen to live a life of dignity yet. We can't make you do it. We've tried. You have to do it for yourself, sir. I'm going to credit you time served. You do owe the court $205. It looks like for fees. How do you intend to pay that? Of course, your mom's going to pay it. She going to pay that today? Did you know you were going to pay that, ma'am?
No, I did not.
Wow. Still no decision to take responsibility. Your mom's going to pay it. And when are you going to pay your mom back?
First.
On the first? Okay. How about you come pay on the first and not your mom? Because grown men take care of their own bills. How about that?
How much was the balance?
It's 205. Are you paying the full 205 on the first, or do you want a payment plan?
Just feel too far.
The full 205. Your probation status is revoked or terminated unsuccessfully. I'll credit you the days that were served, and we will pay your balance of 205 by August 1st. That's when we pay actually. August 3rd. I pray, and this is my earnest plea for you, sir, that I don't have to see your name in the obituaries or the news. Do you understand that? Best wishes to you. Martin Torres, please start your video. I don't even see them yet. Hello? How can I help you? I can't hear you. We can't hear you. Does he have a case? I don't know what you're looking for, Mr. Torres, but we don't have a case for you. You might be in the wrong courtroom. David, that's not it. You may be in the wrong courtroom. And we can't hear you, so I can't assist you. You need to call the court if you're looking for 54A District Court, okay? Call the clerk's office and find out where you're supposed to be. Okay, thank you. You can be seated. Okay, I can have everybody turn your attention towards the screen. I do have some instructions for you. You okay? Oh,
Yeah,
okay.
how are you?
Oh, you're fine. I just didn't know if you needed something. Okay, ladies and gentlemen of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. If you could please stand and raise your right hand. Okay, do you each solemnly swear or affirm that in the action now before the court that you will justly decide the questions submitted to you and that unless you are discharged by the court from further deliberations, you will render a true verdict and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court? If you do so, say, I do. Thank you. You will get a written copy of my instructions that I'm about to read to you, but you won't get them until it's time to deliberate. You will then be able to refer to them. Since no one can predict the course of the trial, these instructions may change at the end of the trial. At the close of trial, I will provide you with a copy of my final instructions for your use during your deliberations. Now I will explain some of the legal principles you will need to know and the procedure we will follow in this trial. First, let's talk about the elements of assault and battery. The defendant is charged with the crime of assault and battery. To prove this charge, the prosecutor must prove in count one each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery on a Garrett court. A battery is a forceful, violent, or offensive touching of a person or something closely connected with the person of another. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Garrett Hort's will. It does not matter whether the touching caused an injury. Second, that the defendant intended to either commit a battery upon Garrett Hort or to make Garrett Hort reasonably fear an immediate battery. Count two, also assault and battery. The people would need to prove beyond a reasonable doubt, first, that the defendant committed a battery on a Warren Wright. Again, a battery is a forceful, violent, or offensive touching of a person or something closely connected with the person of another. The touching must have been intended by the defendant, that is not accidental, and it must have been against Warren Wright's will. It does not matter whether the touching caused an injury. Second, that the defendant intended to either commit a battery upon Warren Wright or to make Warren Wright reasonably fear an immediate battery. The prosecution must also prove beyond a reasonable doubt that the crime occurred on or about December 31st, 2025 in the city of Lansing, Ingham County. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may, or she may, make an opening statement after the prosecutor has made theirs, or they may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing argument. Like opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of this case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of the case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's race, national origin or ethnicity, gender or gender identity, or sexual orientation or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions and argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my own opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts of this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. You would raise your hand, write your question down, and pass it to my court officer who will give it to me. Do not show your question to the other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question is not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of this case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of some other matters that have nothing to do with this case. Please pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. You must not talk to the defendants, the lawyers, the witnesses, or anyone who may be connected to this case. This means you may not speak to these individuals even if it has nothing to do with this case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and you are not allowed to discuss the case. If they continue, leave and then report the incident to my court officer as soon as you return to the court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. The restrictions I am about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider must meet certain standards. For example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from your jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigations or experiment using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phone or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media, websites, or in any other manner. If you discover that a juror has violated my instructions, report it to my court staff. You may take notes during the trial if you wish, but of course you do not have to. If you do take notes, you should be careful that it does not distract you from paying attention to all of the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. As you can see, we have chosen a jury of 7. After you have heard all of the evidence and my instructions, we will draw names to decide which one of you will be dismissed to form a jury of 6. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instruction as a connected series. Taken together, they are the law that you must follow. After my final instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after you have listened to and considered all of the opinions of the other jurors who may have different backgrounds and perspectives from yours. Opening statement.
All right, thank you all so much for bearing with us through what's already been a long day. We're just getting started. So I really appreciate your jury service. I know it's not easy. I know it's a burden. I know that you have dogs to let out. So I really appreciate you guys here. This case is about an assault. And it's not, as you may have asked in jury selection, it's not the type of assault you always picture of getting punched in the face, getting kicked, getting stabbed. It's not like that, but it is an assault. I said to you that we are going through a crime. This happened at the Kristen Community Center. We have 2 victims here, both of whom were working security at the Kristen Community Center. And you're going to hear testimony from both of them. And the evidence will show that this defendant came to this community center and decided that he did not want to go through security. He did not want to be searched and metal detected for weapons. And he started trying to barge his way through, started trying to push his way through. And our witnesses, you're going to hear from Garrett, you're going to hear from Warren. Garrett's going to tell you about how he got in the way to try and keep the defendant from getting in there without knowing if he has weapons, without knowing if he has drugs or anything like that. And how he got forcefully pushed his way through, how the struggle continued into the back. How Warren, our other victim, tried to jump in, also got pushed around. And you're going to hear about how Garrett went down and injured his knee. And while injury is not an element with respect to Warren, you are going to hear that there was an injury. And I am going to ask you to conclude beyond a reasonable doubt that what happened, this shoving and this pushing and this body checking was an assault, was 2 counts of assault. Now, as far as the witnesses you're going to hear from today, we have 3. We have Garrett Fort. He is going to tell you about working there that day, about the security protocol, about his job, about what happened. We're going to hear from Warren as well. He's going to tell you mostly the same things. Garrett is going to tell you about the injuries that he suffered. You're going to be seeing him kind of limping in because he still is dealing with the effects of injuries from this incident. And you're going to hear from Sean Latino, who is a police officer, who took a statement from Mr. Gary about what happened here. And you're going to see some video clips from that statement in which you don't get a clear narrative from what happened, but you will see that he felt antagonized, he felt mad, he was expected to comply with the security requirements. He felt insulted that he needed to be searched for weapons. And that is why, well, I don't need to prove motive. You're gonna see that that is why he did what he did, why he lost his temper, the way that he lost his temper. And additionally, you are going to see videos of these assaults themselves because there is security at this community. So we're going to get two different angles coming. You're going to see how it starts. We're going to see a video where he barges into Garrett and with Warren trying to intervene. You're going to see a different angle with them backing up the frame and then going out. You're not going to be able to see it for a second. You're going to see the defendant and Warren come back out. And you're going to see the defendant push Warren. And you're going to see all that on camera. You're going to watch these two assaults with your own two eyes. And then after all that, I'm going to come back to you and I'm going to ask you to trust your eyes, trust what you saw, trust what you heard, and find the defendant guilty of both count 1 and count 2, assault and assault. Thank you.
Are you going to give him a statement now, or did you want to?
I will proceed now. Good afternoon, members of the jury. Thank you for being with us through this long and hot day. And thank you for bringing your time and attention to this important case. Now, today you're going to hear a story, but not all stories are based in fact. Some are colored by assumption, emotion, and misunderstanding. That is exactly what we're dealing with here. A security guard improperly initiating a physical confrontation and then claiming that they were assaulted. Now, this is a case with very limited actual evidence. Your only insight into this incident will be the viewpoints of security guards, Mr. Hart and Mr. Wright, and very limited video of physical struggle. You have to listen to these stories and decide if it is believable within a reasonable doubt. While the state plans on calling another person, an officer that may have been around the incident, the responding officer, the only eyewitness testimony that you will be hearing from the prosecution will be of the security guards, Mr. Hart and Mr. Wright. And Mr. Gary will also be testifying in his defense. Now, Mr. Gary, this is a man who initially consented to being searched, as he will testify to. He felt violated by what he felt to be excessive searching and handling of his clothing and person, and then simply wanted to grab his book bag from inside of the community center when he was told to leave. State, and I want you to believe that Mr. Gary suddenly became violent, threatening, with no provocation. This allegation of a sudden switch in temperament is a leap of logic that should not be followed. Because here's what the facts will actually show. One, there's no officer on the scene who saw any assault by Mr. Gary or otherwise. No officer was present for this at all. You will hear that Mr. Gary simply wanted to go grab his book bag and leave when he was snatched up violently by security. You will see through the video, the response of the security detail was vastly disproportional to Gary's actual actions. There is no footage of an enraged, violent man. Simply a man who himself was violently confronted by security for the crime of walking to grab his belongings. So, and you will see that it was security that was in the wrong for escalating this into such a violent fashion. The law is clear. To find someone guilty of assault, the prosecution must prove three things beyond a reasonable doubt. That the defendant attempted to commit a battery or acted in a way that would cause someone to reasonably fear an immediate battery, and that the defendant intended to do this. An assault is not an accident, and that he had or appeared to have the ability to carry it out. And finally, remember this: the defense does not have to prove anything. We don't have to explain why someone made a false statement or why someone misunderstood what happened. The burden
every ounce of it, and proving whether Mr. Gary is guilty belongs to the prosecution. And they must prove that case beyond a reasonable doubt. Now, more on this burden. You believe the state's and Mr. Hart's and Mr. Wright's version of events. That's the only way towards a guilty verdict. If you do not believe their version of events, that is a not guilty. But most importantly, if you are not sure, and that this hesitance is because you have a legitimate and reasonable doubts about anything that the prosecution has put forward, that is also a not guilty. Now, members of the jury, when all of the facts are laid out and this very limited evidence is seen clearly, I believe you'll agree. Therefore, at the end of this trial, we, the defense, will ask the client, Mr. Gary, not guilty. Thank you.
People call Garrett Ford.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
You can have a seat. Okay. And so there's a microphone that's in front of you. The purpose of that is to be able to pick up sound. Is it not enough? It's really tight. Is there enough space for you?
Just no problem. It should be fine.
I'm sorry?
As I said, I think it should be fine.
Okay, very good. Okay, and so the purpose of this microphone that's in front of you so that the sound can be picked up by the recording system. It will not amplify your voice, so if you can keep your voice up, it's been good so far. All of your responses must be verbal. We can't articulate into the record head nods, head shakes, or and uh-huh. So if it's a yes or no, we need you to respond yes or no, okay?
Yes, Your Honor.
If either of the attorneys would make an objection, you stop speaking immediately. Their objection requires me to make a ruling on their objection and then determine if you're lawfully able to respond to their question, okay?
Yes, ma'am.
Did you state your first and last name and spell both?
Garrett Hart, first name spelled Garrett, last name spelled Hoerd.
All right, Mr. Hart, thank you for being here today. Could you tell me where you work?
I work at the, it's formerly known as Cristo Rey. It's now technically Catholic Charities of England, Eaton, Clinton counties. It's a sort of a service center where people in need can come and get food, clothing, all sorts of items they need.
How long have you worked there?
I haven't been back to work since my injury, so that's been 7 months, but I was working there for, I think, maybe 6 months before the injury.
And what were you doing there before the injury?
I was a security supervisor there.
And what sort of responsibility did you have as security supervisor?
Scanning in guests, patting guests down, and just being on guard for any security situation that pops up, any fights or anything like that. Mainly those scanning in guests and making sure they don't have any firearms, weapons, drugs, alcohol, all those things that aren't allowed on the Catholic charity grounds.
Now, talking about the things that aren't allowed, what steps does a member of the public need to go through in order to enter the community center?
You just walk in and we have a metal detector and we'll wind you down. Sometimes we do pat downs on occasion. Just if we sense something or if they're being elusive, or anyone can decide they don't want to get searched and just leave the building. It's not-
So if
fine.
someone is giving you reason to be a little suspicious, you might pat them down before they go into the building.
I would start with a metal detector, and then if I found something, then they would repeatedly tell me there's nothing there, but I'm clearly getting like a beep or setting off metal detector, then I'll check.
So you don't always do a pat down, but sometimes you might do that.
Correct.
And were you working as security with Kristen Ray on December 31st last year, New Year's Eve?
Correct.
And were you working as in your role as a security supervisor?
Yeah.
And did there come a time when you had contact with someone named Maurice Gary?
Yes.
And Maurice Gary, is this someone who you had known previously?
Not previous to the job, but had past interactions with him prior to the date of consultant.
So prior to December 31st, you had interacted with him through your job at Kristen Ray?
Correct.
And do you see him in the courtroom right now?
Yep.
Could you please tell me where he's sitting and describe his clothing?
Defendant's seat right there with a green button-down shirt.
And the witness pointed towards the defense table, and could the record reflect the witness has identified the defendant?
No objections.
And the location where you work, is that at 1717 North High Street?
Correct.
Is that in the city of Lansing?
I believe so, yes.
And is it in Union County?
I believe so, yes.
And did you have contact with Maurice Gary on December 31st, 2025?
Yes.
And was there a time when he tried to enter the community center?
Yes, he came in, got scanned down just fine, went downstairs to eat or whatever his business there is, and then left and wanted to come back in. When you come back in, you still have to switch people put knives, everything on the ground out there. So anytime anyone comes back in, we have to search you. And the
So,
client.
sorry to interrupt. So, correct me if I'm wrong, sounds like you're saying that he peacefully went through security and then did whatever he did inside the building and then left. Is that right?
Yes. And then
at that point, he came back in?
Yes.
Did he completely exit the building?
Yes, he walked out the doors in the time we're talking about.
And do you always research a person when they leave the building and they try to come back?
Yes, anyone who's a client there, who's with the, what we call the guests or clients, anyone who's a client there gets searched when they come in through those doors. If they go out for a smoke, come back in, you still get searched through, just similar to downstairs. If anyone comes in, just gets searched.
And when the defendant re-entered, did you attempt to search him before you go back?
Yes, I believe my partner, Warren, was initially conducting the search of Mr. Gary. And then once he became agitated and threatening, I stepped into as supervisor to intervene and attempt to de-escalate the situation. And then in about 10 seconds, he was assaulted.
Now, when you say he was assaulting you, what did he do?
Shoved past me, tried to shove me down, and at that point, I can't allow someone in the building who's assaulting people, so I had to physically remove him. So I started doing that, and then.
So initially, he was shoving you. Did it seem to you as though he was like trying to shove you or like trying to get past you? If you could tell.
I think he was trying to attack me. I'd already threatened to, and part of my language, he threatened he was going to beat both of our asses before any altercation had started.
Okay. So prior to anything physical happened, he was threatening to beat your ass?
Yes.
How many times did he say that he was going to do that?
A couple times. I couldn't recall exactly the number of times, but he told me to my face, I'm going to beat both your guys' asses. And you can't just let someone in the building who's doing that threaten people.
And as he's trying to get in, and are you and Warren at this point trying to remove him?
We were trying to talk to him at first, and he didn't want to be searched now after leaving and then coming back. He didn't want to be searched now. So I was watching Warren try and de-escalate the situation, and then Mr. Gary became agitated and upset, and I attempted to take over the situation in order to de-escalate it. And I had about 5 seconds of de-escalation before he was shoving into me and trying to attack me.
All right, so let's start with the shoving into you. Did there come a time when you wound up on the ground?
Yes.
Can you just walk, to the best of your memory, walk me and the jury through what happened between the initial shove and you winding up on the ground?
I grabbed Mr. Gary in order to remove him from the building. Started walking towards the door and he was struggling, and in the struggle, my knee got injured. And then I was on the floor because I couldn't get up. I had a kneecap all the way out to here.
Your kneecap was dislocated. Is that what you said?
Yes, my kneecap was all the way out to the right side of my knee. Completely dislocated.
And was he still like pushing or thrashing or anything like that when you were sort of trying to get him out?
Yes.
And did you see, after you went down and your knee was hurt, did you see what he was doing from there, or were you just focused on your knee?
I went down and I couldn't get back up to chase him or anything. I saw him run away from me, and at that point I couldn't do much more, so I was worried about my knee at that point.
And then did you wind up seeking medical care that day?
Yes, I had to go to Clarion Hospital by EMS, and they put me through a whole bunch of procedures to reset it. And I don't know exactly all the medical details.
And is it something that's still impacting you?
Yes, I might end up on disability because I can't. It's not getting better. It's still a bit of plateau in my recovery. They say I don't know if I'll ever work a full-time job like I want to again. I've been out of work for 7 months, losing I don't even know how much money. I just can't do anything. I can't shoot basketball hoops. I can't go on a hike.
So getting back into it December 31st. Sorry, I wasn't trying to
No, you're
interrupt
good.
you, just trying to keep us focused on the 31st. So I apologize about that. We'll start with now, to your knowledge, was there any security footage of what happened?
Yes.
And if you were to see this footage, would you recognize it?
Yes, I've seen it before.
Like, Your Honor, I'm showing the fence table people's code exhibit 1. Your Honor, may I first witness?
Yes.
Now, is this one of the security videos?
Yes.
And that video does it fairly and accurately depict what happened?
Yes.
I'm going to show the fence table proposed exhibit 2. Your Honor, may I approach again?
Yeah.
Approaching with exhibit with people's 2. Now, is that also video of this incident?
Yes.
And is it likewise fairly and accurately depict what happened?
Yes.
Your Honor, with some of the people move to admit proposed exhibits 1 and 2.
No objection.
Not objection.
Now, pardon my lack of technological prowess while I attempt screen share. Okay. Now, this person right here with the security written across the back, is that you?
Correct.
And this person here with the stripes on his shoulders, who is that?
That is Warren, the other officer on duty that day.
Okay. Now, this person right here you're interacting with, who's that?
Maurice Lamar Gary.
The person you identified in court today?
Correct.
Okay, going back to the beginning. Now, is this before or after he was threatening to beat you guys up?
Before, when you see me point out the door there, that's me telling him to leave because he has threatened to beat our asses. I can't, I mean, as a security supervisor, I can't let anyone who's threatening to beat people up in the building. It's just
Okay, so you're directing him to the door.
Yes,
directing him to
you
leave.
have to leave, you can't come in, you just threaten to beat us up, you can't do that.
Now, at this point, initially, is he trying to like walk around you?
Yes, he's trying to ignore my directions and just walk past me. And
this
he knew
is-
that would.
And this is immediately after you directed him to leave the building.
Correct.
And at this point in time, had you successfully searched him?
No, the first
So-
time when he entered the building the first time, then he exited to do whatever, and then on his re-entrance of the building, he hadn't been able to perform a successful search yet. No.
So at this point, did you have any way of knowing if he had any sort of weapons on him or drugs?
No.
And would it have been responsible of you to let him into the community center not knowing if he had weapons or drugs?
No.
So then right there. Was that him sort of shoving off of you?
Correct.
Did you give him permission to shove you like that?
No.
And this doorway up here, is that the entrance into the building?
Correct.
I'm moving to people's too. Try to move to people's too. Apologize for the technical difficulties. That's okay. Now, what is this desk area up here?
That's the front desk where any client can come ask questions, get clothing slips and other various functions.
And then what is down this hallway over here?
Past that, you can't see, I don't know if we have a camera angle of that, but there's a doorway right past where we're heading. That's the doorway I was attempting to remove Mr. Gary from, attempting to keep the momentum going towards the door. And then,
So is there like an exit out the building this way?
yes, there's right past where you can't see there's a doorway right there.
And what is up here?
That is down the hall towards cafeteria, all the clothing closet and all of the services that we offer at Cristo Rey.
So when he initially stepped around you, was he on this side going towards
Correct.
this hallway? Now play exhibit 2. Going back. And at this point, is that still you and Warren and Mr. Gary on the floor?
Correct.
Now, can you just, to the best of your memory, walk me through what happened when you were out of the screen in there?
Me and him were struggling. I was attempting to force him towards the door and out the door. He was fighting back against that, and in that struggle, my knee was injured, and I went to the floor. I couldn't get up.
When you say he was fighting back against that, what was he doing?
Wrestling with me, not letting me put him out the door, and
Was he
fighting.
initiating physical contact with you while that was happening?
Correct.
And this was this after you told him that he needed to leave?
Yes, I told him he's no longer welcome today. You can't threaten employees on the grounds and still stay there. It's a big no-no.
Now, these two people out here, is that Warren and Mr. Gary?
Correct.
I have no further questions. Thank you.
Hello, Mr. Hardy. So we're going to go over a little bit of your testimony, including the video that all of us in this courtroom just watched. Now, it's true that you had initiated contact with Mr. Gary when he attempted to walk in, correct?
Contact is in searching him down. Yeah.
Okay.
But anyone who comes in, stop him at the door and say you have to send to a search or we can't let you in here.
Okay. And you said you had already knew Mr. Gary at the time?
Yes, he was a regular at the Cristore facility, so I knew him.
Okay. And had you ever had any complaints about him before?
Yes.
Okay. Is it true that at this time that when he first entered into the building, that was when he first entered into the building before he left and re-entered? It's true that there was no incident occurring that day, correct?
Correct.
Okay. And you did initially search him when he entered the first time?
Correct.
Okay. And what did the search entail?
Metal detection, we wand everyone down. Anything metal has to be taken out of the pockets. If we have reason to believe that there's something in the pocket and if we're clearly being lied to, but it's not metal, like to say methamphetamine or drugs or a glass pipe or a glass bottle of beer or anything like that. If you see a big bulge, we'll ask you to remove whatever's in your pocket so I can see it.
Okay.
Things like that.
Okay.
And occasionally I have to do pat downs when people say there's nothing, no matter what, you tell them, it's obvious it's there and like, okay.
So when you initially searched him, right, it's true that you didn't find any contraband, correct?
Correct.
Okay. And after that, you went out for a smoke break and then returned back.
If that's what he did, correct. I don't know what he did when he went out the door.
Okay. And you said that when he re-entered, that he had appeared suspicious when he re-entered. This is in testimony, didn't you?
The only thing that made it suspicious was not consenting to the search and attempting to evade the search, and there wasn't any suspicion on him before the search. We search everyone who comes in the door.
Okay. Do you remember how long that he was outside?
No, I do not recall.
And when he came back in, you attempted to initiate a search. How did you attempt to initiate that?
I think it was Warren who initiated the second search initially. And then once he became agitated with Warren and clearly weren't going anywhere good, I stepped in as security supervisor to attempt to defuse the situation. And then he's immediately threatening DRSs.
So he just appeared spontaneously agitated. There was nothing said to him at all.
I'm not sure. I couldn't speak on what happened between him and Warren. I inserted myself in the situation once I saw Mr. Garrett becoming agitated and attempted to de-escalate the situation.
Okay. And say you attempted to de-escalate the situation. Do you remember what you said to him?
It was 7 months ago. I do not recall exactly what I said. No.
Okay. So it's possible that you had said something that provoked him, but you just don't remember. Is that a possibility?
No.
Okay.
I don't. I mean, I'm very respectful to anyone who comes in those doors. I don't provoke anybody. I greet everyone with a smile. Even those who have previously had situations there, I treat them all and don't have any different acting towards anyone who touches me.
Okay. But when he first came into to Crystal Ray, you were able to search his pockets pretty well initially, right?
Yes.
Okay. And you previously mentioned that you didn't find anything. When he re-entered, was there any reason for you to believe that he had stepped out for contraband?
No, just like I said, anybody who comes back in those doors, we just search them again anyways. I mean, it's tons of people walk out, have a cigarette, and I watch the whole time having a cigarette, and then I search them and come back in. It's not nothing like that.
Okay. Now, you said that you saw Mr. Wright attempt to wand him.
Yes.
Okay. Do you remember any type of beeping or anything like that?
I do not recall. It was 7 months ago.
Okay. So it's possible that the wand didn't go off at all, that there was no metal on his person.
I
Correct?
do not recall.
Okay. But so it's a possibility that the wand, the security wand, did not go off at all. Correct?
I do not recall.
Okay. Now, I want to move on to this injury that you had alleged to have happened. Now, it's true that you stated to police in your statement that your knee issue was actually a reoccurring issue and not something that was a cause because of the struggle, correct?
I don't remember stating it like that.
Okay. Do you remember giving a statement to police?
I think so.
You think you remember?
I mean, I don't remember exactly giving a statement. I'm sure I gave a statement. I don't recall exactly when it happened.
So you were not sure if you spoke with the police after the incident? Is that your testimony?
No, I'm saying I don't remember when I gave the testimony. Is that what you're asking?
No, I'm asking you, okay, first, did you speak to the police and give a statement?
Yes.
Okay, and when was this?
I do not remember. If it was right after, I don't remember.
Okay. So you don't recall the statement. You don't recall whether the statement was that day, whether it was the next day. You don't recall anything.
I think it was that day, but I don't remember exactly when. I mean, it was a high stress situation. I was injured, had my knee busted out, so I don't remember exactly when they took my statement.
Okay, but you do agree that you did give a statement to the police?
Yes.
Okay, and you were saying now that you do not remember saying anything about your leg already being injured before this occurred. Is that what you're saying?
I'm sure. Yeah, I don't remember. It was 7 months ago.
Okay. Now, if you were to reread your statement, do you think that would refresh your memory?
I don't know. It could. I don't know.
It could.
I couldn't tell you. I don't know if that's.
Now, with you saying that it could, I want to take that to the affirmative. I believe that there is a statement that I from the the statement that he gave to the police, I would ask permission for him to refresh his memory.
You have that statement?
Yes.
Okay.
Would you consider your memory refreshed?
No, I mean, I don't remember. It was 7 months ago. I don't remember the statement. I don't remember. It was 7 months ago, so I don't recall exactly what I said or to the police that day.
Okay, so you are not prepared to, your memory of that day is so confuddled or confused that you cannot remember a statement made about a knee injury, which you claimed really bothered you. You can't remember that at all.
What do you mean? I'm sorry. You mean,
I'd asked you that it was true that you stated that you previously stated to the police that your injury was more of a, was previously bothering you and injured, and that you don't believe that anything that transpired with Gary caused the injury.
I do not remember that. No. I had previous knee injuries, but I don't, like I said, it was a stressful day 7 months ago, and I don't remember exactly what I said to whatever cop I wrote that. Couldn't recall. Sorry.
Is there a rule book for conduct for how to handle people who injured?
It's just general security principles of treating them with kindness, fairness, and I mean, there's not really a written general rule book, I guess, if you would say.
There's no conduct policy for how to handle someone that's entering. You're just going off general principles. Are these principles? They're not written anywhere.
Not that I know of. No.
Okay, so if someone is attempting to get in to the center, you're basically left to your own devices to decide how to handle that.
No, I mean, I've been trained and
trained how?
As a security supervisor and other security roles. I used to work in a hospital and other places, and have experience in de-escalation, understanding. Everyone has, I mean, I'm not sure. I mean, no, there's no rule book I opened up on how to deal with this exact situation. It's like I don't understand the question of this.
Okay, so my question being that sometimes when there can be verbal confrontations, you were saying that you were trained in de-escalation and that you had attempted to de-escalate the situation. However, the video showed, and you also stated that you agreed that you were the one that initiated contact and he tried to walk past you. That is correct, right?
You mean initiated when I put my arm out to stop him?
Yes.
Yes.
Okay. And so you're trained to make physical contact and initiate physical confrontation with guests if they try to get in?
Correct.
Okay. And is there any line for how violent you're allowed to get?
Well, I would say I wouldn't get violent, and specifically when you don't ball your fist up or anything. If someone's assaulting someone or attempting to force their way into the building, you're allowed to grab them and try to physically remove them, but no punching or anything like that. And obviously, if you kick someone on the ground.
Okay, so you're saying that grabbing, you, instead of using your words, you grabbing him, that's not an assault in your ass?
Well, I didn't grab him. I put my arm out like this, if that's what you mean, to stop him from continually walking down this way, and then he just forced his way into my arm. If that's what you mean.
He forced his way into your arm?
Yes.
Okay.
Yeah. Could have stopped me when I put my hand out to stop him, but instead of stopping, he forced his way past.
Okay. So you're saying that you didn't grab him on that video?
After he had started assaulting me, I did grab him in order to get him out of the door, so it couldn't hurt anyone else or me. That was the plan.
Okay. Now, earlier you said that when they were off camera that you were struggling. That was what the word you used. Now, struggle sort of applies back and forth, does it not?
Yes, I was attempting to force him out of the building for threatening employees and actively assaulting employees, and he was attempting to force his way into the building.
Okay.
So yes, I would say there was back and forth.
Okay. Now, you had said that he had threatened employees, threatened to beat their asses.
Correct.
Now, was there anybody else around that could have heard this, or was?
Correct.
Okay.
Warren was right next to me when he said that.
Okay. It's correct. It's accurate to say that during this entire ordeal that Mr. Garrett did not throw a single strike or punch. Is that correct? Did you ever hear did you ever hear Gary mention anything about him needing to get anything from inside of Crystal Ray when he was trying to re-enter?
I do not recall.
Okay. You don't recall him mentioning that he needed to?
Jackie calls for hearsay.
Do you want to respond to the objection?
Do I say-
No, I'm talking to the attorney.
Well, I think we had mentioned that, or we had established that he was stating that Mr. Gary was very angry at the time. And I do think this was a highly emotional and charged response.
What does that have to do with your say objection?
Well, I think he was.
Is this admissible hearsay or no?
I think it would be admissible. I think that he was describing his no, I'll withdraw and I'll rephrase my question instead. Now, I'm not going to ask you specifically what he said, but do you know, or do you would you have any idea why he needed to get back into the Crystal Bay?
I do not recall knowing. I have no idea why.
No other questions.
Now, the statement that you gave to the police, well, you don't remember exactly when it was this before or after you dislocated the camera?
I would assume after.
Now, at the start of the video, that we watched earlier at the start of the interaction, was your kneecap in place at the start or was it out?
It was in place.
And then your kneecap did it pop out during the struggle?
Correct.
Now, have you ever previously dislocated your kneecap?
Yes.
So is it possible that you told the police, this is not the first time I've dislocated my kneecap?
I do not recall, but yes, that would be possible, I guess.
You just don't remember what you told the
Yeah,
police
it
about?
was 7 months ago, and I was more worried about my knee than anything else really at the time. And I'm sitting there with my kneecap out to here and in a lot of pain, so I don't recall exactly what was said or on that day.
And the Mr. Hardy, did he approach you with a written statement?
Yes.
And was that something that you wrote?
No.
Was that something-
My name was spelled.
So that was actually already answered the question. Now, you had some questions on cross about, I guess, let me put it this way. When you put your arm out to stop him from getting into the building, was that after you already used your words to tell him to get out?
Yes, when I'm pointing towards the door, that is me physically motioning, you have to leave as I'm pointing and saying that. So after I told him he had to leave, then he started trying to force his way past us. And I put my arm out to try to keep backing up and he can't, and then he just started shoving past us and it all devolved.
No further questions.
Questions from the jury? Write your questions down. I'm sorry, I didn't ask anybody to approach me. Why y'all closing?
I apologize.
It's the worst of habits.
Don't rush.
Good approach. Here's another question. Okay. Was the defendant ever made aware he was going to be removed from the building before he was grabbed?
Yes.
And was it ever explained to the defendant why he was or had to be searched again?
But as I said, Mr. Gary is a regular there, so he knew already that anytime he comes into those doors, he has to be searched. So that specific day, we hadn't explained it again to him because he already knew. He would.
Well, you can't say what someone knows because that is cause for speculation.
Okay.
But are you aware that he had been explained the rules?
Yes, he understood the rules.
Okay. Well, no, he had been explained the rules. I think he understood the
yes.
rules. Thank you. And I think, is there another question?
I have one.
Okay,
more
we have another
question.
question.
Personal
I think.
I agree.
Yeah. Okay. All right, we've asked all the questions at this time that under the court rules would be appropriate or relevant to the incident. So any other questions at this time? Okay, any redirect or cross based on those questions?
Yes.
Do you have some redirect or a recross, I should say?
Yes, I have,
We'll let him recross and then you can do your redirect after.
Of no further.
Thank you.
now this frame right here in exhibit 1, where your hand is up going towards the door, is that when you told him that he needed to leave?
Correct. That is.
You're gonna have to put on the screen because the jury got to see that.
I was trying to.
And
Thank you,
using this
Judge.
little dandy pointer that you have. God bless you.
So is this the point when you're explaining to him that he has to leave?
Yes, because at this point he has threatened to beat both our asses. So I explained to him, you can't come in after saying that. You can't have people threatening employees on the ground. So you gotta go. That's all that was.
And then right there, is that the first physical contact?
Correct.
So it was after he defied your directive to leave.
Correct. I directed him out the door, told him can't do that, and immediately started enforcing with asses.
Thank you. No further questions.
We're unable to ask that question. Any other question? I almost have a question, but it really isn't relevant. Okay, so may this witness be excused?
Yes, Your Honor.
Okay, let me first advise you that there is a sequestration order, so that means you're not to discuss your testimony with anyone else, okay?
Okay.
Okay, you can be excused.
Thank you, Your Honor.
Thank you, and we need to give the jury a 10-minute break. And possibly some snacks. All right, for the jury. You're not free to deliberate yet. We're still in the middle of proofs. You can leave your notes there. Thank you. Purpose of that microphone is to let the system pick up all of your responses. Everything stated in the courtroom must be recorded, okay?
I don't need to press anything to speak.
You do not. You do not. It's not gonna amplify your voice either, so it won't make it louder in the courtroom at all, okay? That's literally just for the recording system, okay? So you need to keep your voice loud and clear, and all of your responses must be verbal. So if you forget to answer a yes or no question and you give us a head nod, we'll just ask you if that's a yes or no, okay?
Yes, ma'am.
If there's an objection from either of the attorneys, you would stop speaking. I will make a ruling on that objection, and then I will tell you if you're allowed to give the response to the question or not, okay?
Yes, ma'am.
State your first and last name and then spell it.
Warren Wright, Warren, Wrighghp.
You may proceed.
Now, Mr. Wright, where do you work?
Crystal Ray Community Center.
How long have you been working there?
I started in October, but I was gone for about a month or so to work at another site, then I was brought back.
And were you working there December 31st, 2025?
Yes.
And is that the location at 1717 North High Street?
Yes.
And is that in the city of Lansing County?
Yes.
And what is your role with Kristen Ray?
Security guard.
And were you working as a security guard on New Year's Eve last year?
New Year's Eve.
So December 31st, 2025?
Yes.
And through your employment at Kristen Ray, have you had interactions with someone named Maurice Gary?
Yes.
What kind of just general interactions have you had with them? How do you know?
It was a guest coming into the community center, typically for the services that we provide.
Do you see Maurice Gary in the courtroom right now?
Yes.
Could you please tell me where he's sitting and describe his clothing?
I'm sitting over there with the green button-up shirt.
Your Honor, could the record reflect the minutes and identify the defendant?
Any objection?
No objection.
Identification is noted.
Now, did Mr. Gary attempt to enter the building on December 31st?
Yes.
And initially, was he able to pass the security and enter the building?
No.
Okay. Now, what sort of security process is there for entering?
So upon entering the building, in order to be let in past security, we are required to look through your baggage. Of course, this is all voluntary and up to the guests coming in. We don't force it or anything, but we do require it as a requirement to enter the building.
So when you say you don't force them, you don't
No.
drag them in and say, you must come in. But if they want to come in, they have to.
Yes, it's a condition of entry.
But they're not forced in.
No, not at all. So upon entry, if they have any luggage, what we're supposed to do is open the bags, see what we can see, and determine if there's anything you're not supposed to bring, which would be paraphernalia, alcohol, things of the sort. As far as checking the person themselves, at the time, we had only one wand. So one of us would use the wand, the other one would pat the person's pockets with the backs of our hands.
Now, when Mr. Gary attempted to make entry into the building on December 31st, were you able to wand him?
I did not use the wand at that time.
Was there someone there using the wand?
It would be Garrett. He was likely using the wand if I didn't have it.
And did you attempt to pat him down?
I did.
And for what reason did you attempt to pat him down?
Because it was a requirement to enter the building to check pockets of any guests coming in.
And how did he respond to being patted down?
He told me, don't touch it.
And was that the first time that you have gone through security with Mr. Gary?
No, that was the first time I had that reaction from him.
So it's not the first time that you've patted him down? Is that a no?
No.
Sorry, we need yeses
Yep,
and
I
no's
hear
for
you.
when Ms. Nash types the transcript.
Absolutely.
And at what point in the process of patting him down did he start to become agitated?
As soon as I patted his pockets, backs of my hands, of course.
And what did he say when you were patting him?
It simply started as, don't touch me. So I responded, if I can't do my job, then I can't allow you into the building. And then it escalated from there.
And what did he say after you told him, I can't let you in the building if I can't take you?
He didn't give much verbal anything after that, after I told him he couldn't come in. things escalated verbally and physically. He started throwing threats, which is when Garrett started to jump in and things started to get physical.
Now, when you say he was throwing threats, what kind of threats was he making?
I couldn't tell you exactly what he said. The only reason I remember them being threats is because I would not respond to the threats, but I do remember Garrett taking the lead on that.
So was he like your boss?
He was more acting supervisor at the time. He had more experience on site.
So when there started to be threats, is that when Garrett became involved?
Yes.
And just to clarify, you don't remember exactly what the threats were?
No, I could not verbatim to you.
Do you remember generally what they were? It's okay if you don't.
Couldn't tell you verbatim.
Now, do you remember how it came to become physical?
So it started out with him trying to push past us to get into the building. As far as my understanding goes, it was to get the stuff that he had brought in earlier that afternoon, I want to say it was morning or afternoon. As things went on, we tried to tell him that we would go grab his stuff for him. We're not allowing him into the building.
So you offered to retrieve his belongings for him?
Yep.
And did that cause him to relent, or did he continue trying to?
There was no response to it whatsoever.
And when you say it became physical, what did he do that was physical?
Started to shove past us with force.
Now I'm going to publish what was already admitted as People's One. Now, I apologize for the lag. Where my cursor is that you?
Yes.
And then next to you is that Garrett?
Yes.
And are you guys sort of there with Mr. Gary?
Gary.
Let me let it play for a
I
second.
was gonna say, it's hard to tell who's all in the video. Yep, yep. So we tried to tell him he wasn't allowed into the building. He didn't like it. He wanted to go in and grab his stuff anyway. So he tried to push past us.
Do you recall, it's okay if you don't recall, do you recall him being told he needed to leave the building?
I was the one that was checking him, so I told him I couldn't allow him in unless I could do my job properly, which was at this point patting his pockets.
Now, at this point in the video, is this before or after you offered to get his belongings for him?
This was, I would say after, but he didn't offer much of a listening ear during the entire altercation.
Now, we're going to go to what was admitted as People's Exhibit 2. Now, is this sort of a continuation of what we were just watching in People's One?
Yes.
Now, I'll let it run for a second. Now, after you guys go off camera, do you remember what was happening in that little hallway after you went off camera?
Absolutely. So in that little hallway, Garrett was trying to push him towards the doorway that's on the other side through that hallway. In that process, Garrett's knee buckled. I just watched him drop. His knee buckled, went to the side of his leg, and he dropped. After that, I tried to continue to get him to go that way, but as you can see, he pushed past me some more to go grab his stuff himself from the cafeteria to leave out the back door.
So in that little hallway, is there an exit?
Yes.
And when Garrett went down, Were you between him and the exit, or could he have just gone to the exit without going by? If you were.
So I was on this side of the doorway, closer to the desk. So I was behind both him and Garrett. He was the closest one to the door. Once Garrett's knee buckled and he went down, he came over Garrett, pushed past me, and then continued down the rest of the building.
So after Garrett went down, could Mr. Gary have simply exited the building without crossing paths?
I would object to his
Absolutely.
speculation.
There's an objection to your response.
I was, asking from his vantage point.
Was it
if
possible?
It was possible for him to go in the other direction.
Wasn't possible speculation, no objection to you. You can answer.
You can answer the question.
Yes, he could have. There was a doorway right behind him.
Right. Now, at this point, we couldn't see what happened in the hallway, but is he like trying to push past you?
Yes.
And at this point, have you given him consent to touch you? Doesn't know.
No.
So then at that point, did he reapproach you after you were walking away?
From what I recall, yes.
Why did you, if you recall, why did you decide to walk away after?
Because I decided to turn my attention towards Garrett once I realized that he was unable to stand back up by himself.
It's right there. Did we see his arms extend? Was he shoving you back?
Yeah. I was trying to keep him from crossing me, but he continued to shove past me. Once I finally decided it wasn't worth it, he threw another threat at me before continuing down the hallway.
So it was after this point that he threw another threat at you?
Yes.
Yes, right after he picked up his phone or device on the ground.
Do you recall what that threat was?
It was just a threat to my life. I can say that much for sure.
As in, was he threatening to kill you?
What's the word I'm looking for? Harm.
Okay. So you're saying he was threatening to harm you?
Yes.
Okay. Was he making threats when he was walking towards you right there?
I don't recall what he was saying right there.
I have no further questions. Thank you.
Cross-examination.
Thank you. Good afternoon. So, just to confirm your testimony, you are saying that you heard Mr. Gary threaten you,
Yes.
but you can't remember anything that he said specifically?
Can you remember anything you said months ago?
Yeah. Well, I would say it depends on what it was, but right now I want to focus on this incident.
You don't answer this question.
I-
He answers your question.
No, I there. But I would like to give my
Thank
perspective.
you.
My perspective.
It's not that kind of dialogue.
So, you're saying that when he re-entered, that's when you had attempted to search him, correct? And you're saying that you didn't use the wand?
No, I didn't have the wand at the time.
Okay. And that you patted him down before?
With the backs of my hands.
Okay. You patted him before down that day?
That day, I could not recall because we also switched walking around the building, patrolling the property as well. So it could have been either one of us.
Okay.
But I do remember as the altercation started, I was the one to check.
Okay. you offered to get, you said in your testimony that you offered to get his stuff, correct?
Yes,
Okay, but this was a very quick interaction. At what point did you offer to grab the stuff?
at the point I offered to grab it was before he could shove past us.
Okay. Now, I'm curious, do you have any type of rule book for conduct?
Such as?
No, just for guidelines for security, for how to make sure people's rights and safety are respected.
Not formal,
Okay.
but we do follow training protocols and such from security themselves, our security company, the ones that contract us.
Okay, and for this for these security protocols, is it allowed, encouraged to get physical with a?
Not unless it's completely necessary. If they're shoving past us, putting their hands on us, we are given the okay to protect ourselves.
Okay. And would you consider that when Mr. Gary had allegedly first started walking past Garrett, you would describe his actions as grabbing him and walking past, wouldn't you?
No.
No. What would you describe it as?
Stopping him.
Stopping him.
Blocking his path.
Okay. And you stated that you remember him stating that he wanted to go get his book bag, right?
Whatever stuff he had in the cafeteria, yes.
Okay. And instead of walking with him to get his stuff, you decided to initiate this confrontation.
Say again.
Instead of walking with him to get this book bag, since this is something that he specifically mentioned was all that he wanted, you decided to initiate this confrontation instead.
We didn't give the opportunity for that solution.
And would you say that he didn't give? We say that he didn't give any opportunity for that solution. What do you mean?
When we denied him entry, that's when he started to tell us that he had stuff in there. As we tried to tell him that we would go grab it, Michelle said that she would go grab it even. He did not like the answer.
When you say did not like the answer, what do you mean by that?
It resulted in him pushing past us.
Okay. So when you were working here, you were still working here for about 2 months prior?
Shorter time, I would say within 90 days, yeah.
Okay, so still relatively new.
Relatively.
Okay, and did you know about any de-escalation rules at that time yet?
I have worked in security for years prior, so I am very versed in de-escalation.
Okay. But at this company that you currently work for, it's true that there was no type of de-escalation taught?
That's not true. We have de-escalation.
Okay.
And training.
Okay. So you have this de-escalation rules, but did you not formally say in your testimony that you don't really have a rule book for conduct?
Yeah, I'm gonna object at this point. I don't know that whether or not there's a rule book for rate for conduct is relevant.
I would say it's relevant that if they are that if there's guidelines for them to avoid from getting physical or violent with their clients like Mr. Gary, that if they're breaking this, I do think that's relevant to the escalation of the situation.
Or de-escalation, I would say.
Yeah.
I agree. Objections overruled. You can answer.
So what was the question?
I'm going to repeat. So you had previously stated that there were rules for de-escalation, but you have previously stated that there's not actually a rule book for
I
conduct.
said there were no formal rules from Crystal Ray Community Center. As far as the contract or contracting company goes that we work for and are contracted through, they prioritize de-escalation before any sort of physical confrontation. It is the same thing with any security company. De-escalation is always the number one thing that any security company I've been with ever says.
Okay. Now, you use the phrase that you believe that Garrett was stopping him when he walked through,
Blocking his path.
blocking his path. Do you believe that this? Do you believe that this was? Do you believe that this escalated or de-escalated the situation?
I don't believe Gary's actions escalated or de-escalated at all. It was the continuous trying to push past us that escalated. It was not our attitude. We weren't angry or yelling at him or trying to mistreat him. It was simply aggression from his part.
Okay. So I want to move on to the situation with Garrett's knee, as I'm sure that you are aware of. You stated that Garrett's knee buckled while he was pushing Gary. Is that accurate?
Yeah, trying to direct him out the door.
Okay, so there was no actual actions that Gary was doing to cause a knee injury, correct? You said that it was Garrett shoving him when he
was shoving back Lamar was.
You said he just dropped. You did not say that Gary pushed him down. You said that he just dropped in your previous testimony. So was he shoved down or did he drop down?
I couldn't say 100% either way. My attention was not on them when Garrett went to the ground. I just know that when I look back, Garrett was in the ground and he was coming my way.
You said your attention was not on them?
No.
So
as you've seen, there was other people behind the desk, and I was worried about.
Okay, so your attention was not on them, but you're testifying that you saw him drop.
I didn't see him drop. I seen him on the ground.
Okay. But drop was the word you used.
Okay, then I'll rephrase. I turned and I seen Garrett on the ground after he fell.
Okay. Now, at any point, do you remember Mr. Gary saying anything about wanting to beat someone's ass?
He said that to me.
He did say that to you?
Mm-hmm.
So you do remember? Why did you say?
Is that yes?
Yes, it is.
Okay. Why didn't, well, you were asked multiple times by both prosecution and myself whether you remembered any type of threat, and you answered no each and every time. So
it's a lot of information that happened months ago. I'm not going to claim my memory is perfect, but yes, the phrase is familiar.
Okay. Now, in the video, you stated that Gary made physical contact with you. Do you agree with that? Okay.
Physical contact, how?
Okay, so I guess.
Which portion of the video are we talking about? The beginning?
No, that's
or
fair.
Or...
That's fair.
Okay.
I am talking about once you move into the hallway.
Okay. Trying to get him toward the next exit, right?
Okay. Would you describe your actions as shoving or pulling at Gary?
Shoving or pulling?
No. Now, in this video, his arms extend.
Mm-hmm.
Okay, and that's when you separate.
Yeah.
Was there any attempt at all for him to shove you, escalate, continue striking you at all?
With intention?
Yes.
So after Garrett hit the ground and I seen him coming my way, my intention was to continue to direct him out the door that we were trying to direct him to. As you can see in the video, we were pushing each other in a circle as he was trying to push past me and I was trying to get him to go the other way.
Okay. But you said that you were pushing and shoving each other. Is it true that you did give a statement to the police on the day of the incident?
I don't recall giving a statement to the police.
You don't recall giving a statement to the police at all, correct?
I don't recall getting my own personal statement, no.
Okay.
If I did and it's read to me, I could remember it, but I don't recall talking to them and giving them my own person.
Okay. Would reading your own statement that was put in the police report refresh your memory right now?
It could help, yes.
Ask for permission to refresh your memory.
So the way this is worded out, unless you rewrote it in your own words, this sounds like I made contact with the other guard one, right? So which means that it's another guard's statement talking about what happened with their contact with me during it.
Mr. Warren, right? Your name?
Yes.
Okay, so once again, now we'll show this to prosecution as well, so we. This is one, right? Okay, so you are alleging that this is not your statement?
The way it's worded, no. The first sentence is I made contact with the security guard, Warren Wright. I would not put myself in a statement that way.
Right. Now, is it true that at the time that you were advised that no punches, kicks, or anything other than pulling away happened?
What was the question?
Is it true that you, and speaking with police, that you stated that no punches, kicks, or anything
I do remember
other than
saying
pulling
that,
away
yes.
happened?
I
You remember
do
saying
remember
that?
saying no punches or kicks.
Okay. No further questions.
I have no redirect.
Any questions from the jury? No questions? Okay, Ms. Witness, please.
Yes, Your Honor.
Okay, there is a sequestration order, so you're not allowed to discuss your testimony with any other witness, okay?
Yes, ma'am.
You're free to go.
Thank you.
Prosecution next witness.
People call Sean McKenna.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
You can have a seat. Please state your first and last name, spell roll.
Sean Rotuno, SEAN ROTUNNO.
Officer Rotuno, how are you employed?
Food City Lansing Police Department,
What's your role at the police department?
police officer,
And what specifically are you assigned to as a police
the
officer?
patrol division.
What does that entail?
Taking calls for service, traffic stops, traffic crashes, investigations, amongst other things.
How long have you been doing this?
5 years.
And were you working in that capacity on December 31st, 2025?
Yes.
And on that day, did you respond to a call that directed you towards 1717 North High Street?
Yes.
And that North High Street address, is that in the city of Lansing, County of Hingham?
Yes.
And were you given a description of a possible suspect?
Yes.
And while you were en route, did you see someone who matched that description?
Yes.
And did you stop to make contact with that person?
Yes.
Did that person come to identify themselves?
Yes, I identified him.
And what is this person's name?
Maurice Gary.
Do you see Maurice Gary in the courtroom right now?
Yes.
Could you tell me where he's sitting and describe his clothing?
Green button-up shirt, two spots over from you to your right.
Your Honor, could the record reflect the next identify the defendant?
We have objection to identification.
No objection.
And did you take a statement from him about what happened at Kristen Community Center?
Yes, I did.
And were you in your police uniform when you took the statement?
Yes, I was.
And does your uniform include a body worn camera?
Yes, it does.
And did your body worn camera capture this statement?
Yes.
Now, showing defense table people's pros exhibits 3, 4, and 5. Your Honor, I have first witness.
Amen.
All right, approaching with proposed exhibits 3, 4, and 5. Now, did you recognize those 3 exhibits?
Yes.
And were those snips from your body cam?
Yes.
And your body camera video, did it clearly and accurately capture your interactions with the defendant?
Yes.
Your Honor, this time the people move to admit proposed exhibits 3, 4, and 5.
Any objection?
No objection.
People's 3, 4, and 5 recommended without objection.
All right, let's start by publishing exhibit 3.
Is this supposed to be sound? Did you share sound with
There is supposed to be sound.
Yeah, you just have to click share sound when you share your screen.
Okay. Okay. Or I had to exit and rejoin.
I'm sorry? Oh,
I
yeah.
had to exit and rejoin. I apologize.
Okay. Mhm. So,
I apologize to everyone.
Hey, let's just step here so we're both staying in the snow.
I mean, y'all can check my stuff. There's nothing in it, like literally. He just want to go. He said, "I'll make sure you don't have no glass." He telling me basically I do dope.
No way to not have the echo.
You have to, is your computer muted?
I just moved my computer.
Yeah, if your computer is muted, it should stop the echo.
For no reason.
Okay.
13, I think we're going to have to endure the echo.
I would have projected that just for maps to be clear.
Yeah, it's not, I don't know what's going on with your device. You're actually supposed to be able to keep your computer muted and then share sound, because if you're unmuted, it always it's going to give an echo. But I don't know why it's not picking up your sound while you're muted. I don't know what it's doing.
Both staying in the snow.
Zoom is telling me that my audio is disabled during screen share.
Your audio is disabled.
That my microphone is disabled.
If you try again.
We don't have no glass.
I'm not gonna spend the rest of our afternoon trying to make this work. I will. Gonna have to play it on my computer, and luckily we're just gonna try to focus on the sound and be able to hear better this way than with the echo.
What's this stuff is posting this stuff? Stuff is nothing in it, right there. He just want to grab. He said, I'll make sure you don't have no glass. So he telling me basically I do dope. I don't do dope. I don't smoke drugs. I'm just smoking weed, marijuana. So why you want to search your stuff? You got a whole metal detector. You got something in there? My bag? No, on you. No, you can check me right now. Okay. Check me right now. Okay. So what happened there, man? So my backpack is downstairs. Yeah. I go in, I take my little vape break. So I come back in, he wanna search, he always wanna top my pocket. It's all right for you to top it, but if you grab me, we got a whole murder check, bro. Then all you gotta do is scan me, bro. I don't have nothing on me, dog. And then I'm squeezing my pockets on camera. I'm squeezing my pocket, there's no glass, you hear nothing breaking, nothing. I still gotta grab your pocket. There's nothing in my pocket. You're supposed to check for knives and guns and drugs. There's no glass, I don't do drugs. Even if it was drugs in there, you can't scan, you're not gonna feel nothing in my pocket. Right. And then when I say, you say then the other dude's like, oh, is that a threat? A threat? What are you talking about? You can't feel my pockets, bro. So then he like, grab your band. I'm like, all right, I gotta get my stuff. He cried, don't touch me. Why you touch me? I gotta get my stuff. And they start trying to grab. And so left. I got my stuff, I left. I didn't touch nobody. He was grabbing on me. I'm sorry to be like upset, but it's like.
All right, now move to people's 4.
So did you? So did you go through the metal detector? Or did you like watch? He did everything he's supposed to do. I took everything off me and put it on the table. After I did this, after I took everything out, I'm showing him. I'm like, scan, you can scan. Boom, I got a pocket here. I got an inside pocket. Boom, everything's on my pocket, so you can't feel nothing. Even if you was to feel on my pocket, so now you just antagonize. So this.
All right, now people's 5.
So I say one thing, I didn't do nothing to his leg. He hit his leg on the wall trying to grab me. And he slipped like this, and then I'm trying to hold him. I didn't know why he was falling. I ain't did nothing to him. Nothing to him. It was just grabbing and trying to release. Like, get off. It was no punches thrown.
Now in that last video, when he said that I didn't do anything to his knee, did you ask about his knee or did he bring that up on his own?
That was unprompted.
I have no further questions. Thank you.
Good afternoon, officer.
Good afternoon.
So, at any point, did you actually visit Cristo Rey where the incident happened?
After, yes.
Okay. But you only came there in the aftermath of the struggle, correct?
Correct.
Okay. So you did not view any of the struggle or physical confrontation, correct?
Correct.
So without having a first person perspective, so you cannot say with 100% certainty that Mr. Garrett assaulted anyone, can you?
No.
Any questions from, any redirect?
No, Your Honor.
Any questions from the jury? Okay, you may be excused, thank you. Any additional witnesses? Prosecution?
No, Your Honor, but people rest.
Okay. This is a good time to adjourn for the day, but we have to come back tomorrow anyways, and it's 4:50. So, You can determine, I guess, if your client, or if you're gonna call a witness tomorrow. If not, we will proceed with closing arguments in the morning and or any motions if necessary. And then final jury instructions and deliberation. So the jury, it should be back here. Here. So the jury needs to get here at 8 because I have hearing, so I need to start early. So that we can get them into deliberation. So that I can do my landlord. So everyone will report back here tomorrow at 8 a.m. You are still not allowed to discuss this case, nor are you to do any experiments concerning the case. Any additional matters for today's record before we release the jury?
Nothing to discuss in front of the jury, Your Honor.
Okay, we can, anything for you?
Agreed.
Okay, we can excuse the jury.
I'll leave.
You do, we have
Yeah, 'cause I
no.
gotta lock them up. She was leaving.